Yes, madam. On Wednesday, madam.
Why?
But the agency, madam, the petitioner ordered to have madam contact madam to run the milk store, madam. After he paid for sale of additional items, madam. That's
Okay.
rejected, madam. However, the last practice of the railway, madam, it says that madam, they can give the permission madam, to sell other products also, madam.
Okay.
Wednesday, madam.
May I please, Your Lordship? I beg to mention item number 48.
40?
48, Lordship. Matter may be adjourned for the day
Oh,
and may be taken along with one similar matter, Lordship.
Item?
48, Lordship.
Okay, you have 40?
Petitioner.
Okay.
Similar matter, one similar matter, Lordship. 5824, only 24.
Your good name?
T. Ahmed.
Okay. On request made by Mr. T. Ahmed. List this matter along with WPC number?
5824. 24.
Okay. Up to 1 week.
2 weeks.
Up to 2 weeks.
Development.
May it please, Your Lordship. Your Lordship, in item number 9, I am the writ petitioner. The respondent authorities have filed an IA for vacating of the interim order. Today, we have filed an objection to that IA, opposite party. We have filed it today. I pray that it may be brought on record today.
Okay.
Obliged.
Lordship, I think to mention for listing introductory applications for stay vacating on 19. Lordship, we have an urgency because appear applicant is IOCL BGR. Lordship, BGR has invited a bid for catering services in Bongaigaon Refinery Guest House, but opposite party has challenged the NIT and without serving copy, they get interim order that.
Okay. Okay. All right.
Mid please, Your Lordship. Look, item number 41, 42, and 43 minutes. And for the repetition, I've taken consent for the other side. Let this matter be adjourned for 2 weeks.
Okay. On request made by Mr. B. Kaushik, learned counsel for the petition. List after 2 weeks.
2 weeks. Grateful.
May I please, Your Lordship? Lordship, I make to mention for listing of on writ petition, Lordship, in admissions column, any date, Lordship.
Okay. 24th.
May I please, Lordship? Lordship, I beg to mention two writ petition, Lordship, similar matter next week. Admission.
Okay. 26.
May I please, Your Lordship? Lordship, I beg to mention a contempt case. Matter may be listed next week.
Contempt matter. Okay.
May I please, Lordship?
26.
So, beg to mention for listing contempt petition, madam, on next week.
First topic.
Yes, madam.
May I please, Your Lordship? My lord, I beg to mention a writ petition for listing, my lord. It's for withdrawal, my lord. 21, my lord.
Okay.
Obliged.
May I please, Your Lordship? I beg to mention item number 14 and 13 for adjournment. Consent of the other side.
You have 40?
13.
13 and 14.
Item number 13, Lordship. I am appearing for the private respondent in all the 3 cases.
Okay. Okay. Your good name?
M. Bora.
You are appearing on behalf of
D. Borgohai.
item?
13, 14, 15.
Okay. On request made on behalf of MS D. Burgohan,
D. Borgo.
learned counsel for the petitioner in WBC number 2744 of 2022.
Yes, Lordship.
How much time?
3 weeks, Lordship.
After 3 weeks.
Applied.
May I please, Lordship? I beg to adjourn the matter of item number 16.
What happened?
The previous council returned the brief, so we will file wakalatnama. We are the
Okay.
newly engaged council.
Your good name?
HG Daisy.
You got his her name?
Item 16.
You are appearing in 16?
No.
Okay. MS
HG Daisy.
learned counsel submits that they are entering appearance on behalf of the petitioner and prays for 1 week time to file wakalat. Praise allowed. List after 1 week.
Pleasure.
May I please, Your Lordship? I beg to mention item number 37, Lordship.
30?
37.
Yeah. Yes.
Excuse, Lordship, I have returned the file, Lordship, to the claim, Lordship.
Huh?
I have returned the file, Lordship.
You are for the,
Petitioner.
you are for the petitioner. So you are not appearing in this matter.
No.
Your good name?
MZ Shah.
And how about TJ Mahanda and R Ali?
They are also.
Mr. MZ Chal and counsel for the petitioner submits that he has returned the brief to the petitioner. Stop. Accordingly, registry is directed to notify the petitioner to engage for engagement of a separate new counsel. Stop. List after 2 weeks. Okay.
Our name may be.
Registry is also directed to delete the name of Mr. TJ Manda, comma, Mr. R Ali and Mr. MZ Shah as the learned counsel appearing for the petitioner in the cause list. Huh? Okay.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 22, lordship. In this matter, R. Sinha, due to some medical urgency, lordship, he could not appear today. The matter may be adjourned for today.
Okay, on request made on behalf of R. Sinha, learned counsel for the petition. List after 2 weeks. Yes.
I think one of daily list motion.
Please, Your Lordship. Lordship, this is the matter pertains to non-payment of the supply of the relief materials. My lord. What had happened in this case, my lord, the petitioner supplied the government relief materials, and out of the total bill of 3,37,13,213, already paid, my lord, 2,93,038,483. But the remaining amount of 79,74,730 not yet paid, my lord.
Yeah, whoever is. But Mr.
RS,
Learned counsel for the petition. By way of the present petition, the petitioner is claiming for payment of the outstanding dues amounting to rupees 79,74,730 for supply of relief materials. Stop. Issue notice. Mr. K. Gogoi, learned additional senior governor, learned Andrews appearance on behalf of
1 and 4, Lordship.
on behalf of the respondent 1 and 4. How about disaster? And Mr. S. Datta, learned standing counsel, revenue and disaster management. Appears for respondents 2 and 3. Notice on respondents are complete, however, extra copies. Respondents are allowed to file a list after 4 weeks.
Master Bless.
My lord, in this case, I have a small prayer. My lord. Yeah, what happened in this case, my lord, petitioner is the registered contractor, my lord. As per annexure 1, my lord, he accepted the works, my lord. Acceptance letter, my lord, letter of acceptance, my
Where
lord.
is that?
That is annexure 1, page 15.
Yeah.
Then lordship next, lordship annexure 2, notice to succeed with the work, my lord. Then next annexure is the completion of the work. In between, my lord, what happened? There is the anomalies regarding the map, my lord. So he has immediately filed representation, my lord. But that representation is not disposed of, my lord, by the authorities, my lord. Though they have assured that they will do their needful during the time of final work, my lord. So my humble prayer before your lordship is that kindly lordship pass an order to dispose of the representation. That's enough. That's prayer before your lordship.
Yes.
I pay for respondent 2 and 3.
Respondents?
2 and 3, national health agency.
Whom did you make the representation?
My lord, last representation is
To the
annexure 7.
mission director.
Yes, my lord. Mission director.
Yes.
We will also dispose of the reference in the option.
heard MSK Devil and counsel for the petitioner. Also heard MS,
It does.
ADAS, Leonard. Standing counsel,
Yes, your lordship.
NHM.
Yes.
And how about Government Health and Family Welfare?
I'll appear, your lordship. Yes, he can
On
appear.
behalf of B. Gogol.
Okay, then you say also heard Mr. B. Gogol.
Yes, sir.
Mr. B. Gogol, Leonard Standing Counsel Health Department for the respondents, one. And MSP does, Leonard Standing Counsel NHM
2 and 3.
for the respondents, 2 and 3. Stop. Para. The petitioner. This is a work order, isn't it?
Yes, my lord. Work order.
Was issued a work order on 17/1/2023,
Yes, my lord.
issued by the Chief Consultant within bracket CW, National Health Mission Assam, for construction of PHC at Kacharitol in Hailakanda district under NHM Assam. Stop. Thereafter, comma, the mission director, National Health Mission Assam, issued a notice to proceed with the work on 16/2/2023.
Yes.
The petitioner accordingly completed this work
Annexure 3.
What is this?
This is a physical status report of the work.
Completed the work and accordingly, the junior engineer within bracket civil, NHM, comma, DHS Hailakandi, issued the physical status report of the work as on 31/2024. Stop. It is the case of the petitioner that in the intervening period,
Yes.
some discrepancy arose.
Yes, my lord. Para 7, lordship.
It is the case of the petitioner that while carrying out the construction work, some discrepancy were noticed in the approved drawing of the said project and the actual work. And accordingly, the said discrepancies were immediately brought to the notice of the respondent authorities. Stop. The further case of the petitioner is that the respondents agreed with the discrepancies and instructed the petitioner to continue with the work by assuring to adjust the same at the time of final measurement and ending public taking over of the project. Stop. However, comma, as nothing was done, the petitioner made a representation before the mission director, comma, National Health Mission Assam, oblique respondent number 2,
Yes, my lord. Mission director.
respondent number 2 on 6/3/2024. Stop. With a request for taking steps. No, just say, no, only the closure. The petitioner again made a representation on 21st January 2025 before the mission, before the respondent number 2 for release of the balance amount of final bill as per plan and estimated approved rate. Stop. However, comma, the said representations are yet to be considered by the respondent number 2 till date. Stop. Para. Learned counsel for the petitioner submits that the petitioner would be satisfied if a direction is given to the respondent number 2 to dispose of the representation made by the petitioner. Which representation do you want to consider?
That,
Made by the petitioner on
21 January two thousand
on
twenty-five.
on 21st on 21/1/2025. Stop. Para MSP thus when the standing council NHM appearing for the respondents 2 and 3 has also no objection. Para. Accordingly, this writ petition is disposed of, directing the respondent number 2 to consider and dispose of the representation dated 21st January 2025 made by the petitioner in accordance with law within a period of 1 month, 1 month, 1 month from today and stop. The outcome of the consideration shall also be intimated to the petitioner draft with the above observations and directions to the petitioner.
Hello, please.
3,
May it please your lordship.
Hmm.
My lord, 3 matters, 3, 4 and 5.
Same.
Same.
Hmm.
Lordship kindly take up item 4. I have seen that petition. These are all same petition, same ground. I will refer to that petition. 4. 1463 WPC.
Yes.
Well, the petitioners here are all LPG distributors. The LPG cylinders, lordship may appreciate that those cylinders are supplied every day, filled cylinders to the distributors. They distribute to the customers in the home delivery. And in the truckload, the cylinders come. And when amongst all these cylinders, few cylinders are found to be defective. When they detect those cylinders, there is a policy that those are to be returned in the same truckload to the company. And it has to be certified by both the agent of the distributor as well as the carrier who carried it from the company on behalf of the company. So these forms are filled up, they certify, and they give the cylinders, including those returns, empty cylinders are to be also returned. They send it. They verify it there, and then when they find that everything is okay, these are in conforming to everything, I mean the procedure prescribed, and things are found to be correct as per those return houses given, they grant the credit against those cylinders what I am entitled to get back the money that they credited to my account. That was done a year back. This is transaction relating to almost a year back. That was over, and that this continues every day. Every day it continues. Same thing. Now they have come up with a notice that look, this was wrongly granted credit to everybody. All these petitioners have been granted a cyclostyle copy of the notice that there was a mistake. You did not complete the procedure. We have granted you the credit. So therefore, why not that will be recovered, and we are recovering it from you. And for that, I need not have to say anything because my account is with them. They can credit, debit from my account. This is a running account with the company because cylinders come, go. I am to keep the balance. They keep on transacting them. Therefore, I am aggrieved by these notices that this is virtually a notice which lacks the, the veracity. It is you who have granted me. On being satisfied, I have given it. Kindly see the how to return. Before that, Lordship may see that notice. I will just
36.
page 36. Similarly, same, exactly same, only the period is also amount may vary, nothing else. This was what they say is that as you are aware, while returning market return cylinders, this is called market return cylinders to the plant, the document ERV should be jointly signed by the representatives of the distributor and the transporter, that is the driver of the truck. In this regard, please refer clause 23A of the Indian Liquefied Petroleum Gas Distributorship Domestic and Commercial Agreement, wherein you have undertaken to faithfully and promptly carry out, observe, and perform all directions and orders or rules made from time to time by the corporation or its representatives for the proper carrying on of the distributorship of the corporation. Recently, a review of the credit debit passed to distributors transporters on account of market return cylinders in the year 23-24 was carried out from North Guwahati BP. The review has revealed that credit has been passed to your PAD account for the empty cylinders returned to the plant, which is equivalent to 1.99 metric ton of LPG and amounting to a total of rupees 1,47,425,925. The said credit was incorrectly passed on onto your account, since the ERV slips were not signed either by the transporter, distributor representatives, or by both, which is in violation of the prescribed policy. It may further be noted that not following the aforementioned procedure is a violation of clause 23A of the distributorship agreement signed between you and the corporation. In view of the aforesaid, you are requested to submit your explanation as to why the following action should not be taken against you: recovery of the wrongly passed credit amount from you by raising debits from your PAD balance. Now kindly come to that 22(3) clause 23A. They have referred to this. What it says? Does it leave anything else to say for me now? My question is this. Does it leave anything for me to be done? Because these are all with you. Lying, I submitted everything to you. As per that procedure, you found it correct, granted the credit. Now suddenly you turn around that, well, either it was not signed or both of them have not certified it. How can this happen? You are the custodian of those records. I do not retain it. Kindly see 23 what it says. Otherwise, they could not have accepted and granted the credits. What is that, please? 29, Lordship may kindly come to.
Page
29. Lord. Here, now, '23. Kindly come to clause 23. Now 23A. The distributor undertakes faithfully and promptly to carry out, observe, and perform all directions and orders or rules made from time to time by the corporation or its representatives for the proper carrying on of the distributorship of the corporation. It shall be a paramount condition of the agreement that the distributor himself, if he be an individual, or both the partners of the distributors from firm, if the distributorship is a partnership firm consisting of 2 partners only, or the majority of the partners of the distributors firm, if the distributor is a firm consisting of more than 2 partners, or the majority of the police office bearers, elected members, distributors, operative society, the distributors cooperative society, so and so. Distributor is a private limited, as the case may be, shall take active part in the management. So it is done regarding management. Now, kindly come to.
That is only only
23A. Yeah, we are concerned with this faithful performance. This distributor undertakes faithfully and promptly to carry out, observe, and perform all directions and orders or rules made from time to time by the corporation or its representatives for the proper carrying of the distributorship of the corporation. We have done it. And regarding the policy, kindly come to page 72. They have formulated the policy. We are bound by that. 72 is the letter. Then kindly come to 73. Policy on market return of Indian cylinders by distributors. Here, kindly come to 1.0. It says, same truckload returns. 1.1. Indian distributor in this category of market return shall return the defective cylinders in the same truckload which has delivered the supply on the date. While doing so, the distributor shall make entries of defective cylinders on the reverse side of the salon. This in the salon, my lord, with the LPG cylinders. So in the reverse side, we have to give all these. LPG 3 or LPG 4. The distributor shall fill in the columns on the reverse side of the challan in all respect, that is as under. Serial number, B, cylinder number, gross weight of the cylinder, tare weight of the cylinder, nature of defect, whether seal is intact. The list will invariably be jointly signed by the distributors and transporters representative. The detail of the recovery / payment will be as per the following guidelines on the defective cylinders returned by the distributor. Now, they have given this everything, we have to follow this. And accordingly we do. And we have given. Way back in the a year back, they got it. They granted us credit.
Apart from it, we also take the information on their portal.
Their porter itself has given certificate there. Therefore, my lord, now by issuing, can you see another aspect? There are almost this 50, nearly, how many petitioners total? 40, total about 49 petitioners in 3 petitions. All have committed the same mistake. A cyclostyle copy you have issued. The very correctness is doubted. Their modus operandi is doubted.
Okay.
Therefore, my response submission, let them show, because what was submitted, they want me, you so called. Well, is it a so called in fact? This is a coercive notice demanding money, and that they will deduct it because it is in their hand. It is in their hand. I have no control on that account.
Have you met your reply?
I have given reply in some cases, but others, we ask for time. We ask for time. That you grant us time. They didn't respond. They are waiting, and there be at any time they can deduct it, take it back, the money. But the question is, my lord, at all, if I am to show cause, what I shall say? I shall repeat the same thing. They know it well. That this was done to you. This was sent as per the procedure. Challan was signed by both of us and was given to you. And you found it correct. You verified it, found it correct and paid us. You paid us. Then what remains? What can I do? What more I can do? This is meaningless.
Chaudhary, you are appearing for the
I
IOC.
am appearing for all the respondents, IOC. My London senior friend has already stated, my lord, the accounts are in our hands. We can pay, we can deduct, recover, we can do that. We have not done it. Your worship will kindly see the notice once again, my lord. The notice that has been issued, that at page 36. Your worship has already read it. The grounds have been taken. The estimated recovery value has not been, my lord, signed. Then, my lord, there was a review. And last paragraph, your worship will see. In view of the above, you are hereby requested to submit your explanation with proofs, documents within 7 days on as to why the above credit debit deduction should not be raised against you. So this is a, my lord, communication asking them to explain. And your lordship will see what is the reply. These are all identical replies. Your lordship will find one at page 54.
Page?
54. Christopher onwards, my lord. There are as many as 18 petitioners in this case. And my lord, it is, the notices are not cyclostyle, and my learned senior friend has stated, figures are different, dates are different. In response to your letter dated February 18, 2025 regarding the discrepancy in credit passed to my PAD account for empty cylinders returned to the plant in 2023-24, I understand the seriousness of the matter and I am committed to resolving it at the earliest. I respectfully request an extension of 30 days to submit my explanation with supporting documents. The 1 week period provided is insufficient for me to thoroughly investigate the matter, gather all the relevant evidence, and prepare a comprehensive response. Identical replies have been given, my lord, by all the petitioners. Now, my lord, my learned friend says, what shall I say to them if I give the reply? Whatever he is submitting with your lordship, my lord, this can be placed before the IOC with the supporting documents. As simple as that, we have not recovered, my lord. We have given them time. They say that the time is not enough. Your lordship will give the time, my lord, 1 month, 30 days time they require. They file a reply. And my lord, after considering their reply, my lord, we pass the order because that is the requirement of the agreement. It says that whatever we ask for, you must give it. My learned friend has already, my lord, shown the provision of the, my lord, part of the agreement. Therefore, my lord, they say, yes, it's a serious matter. We need some time to verify the document and then comes to the court. And my lord submits before the court that what shall I say there? Whatever he's saying.
Have you extended the time?
My lord, your lordship will extend the time, my lord. I have no objection to that. We have not deducted the amount. We have not said anything against that, my lord. 30 days time your lordship will give from the date, my lord, they have asked for 18th of February onwards. 18, 17.
That will expiring tomorrow.
My lord, your lordship will give them some more time, my lord. Already the time they asked for, that is expiring. Your lordship will give them time, let them reply. Let it be considered, my lord. Your lordship will kindly take note of the fact that although we could have recovered on our own without asking them, we did not. We said that you please come and give your explanation. We are considering it, my lord. Let us consider.
Yes, Mahanda.
Whatever time, my lord, he requires, he can take now.
My lord,
This is a
this
previous
is one
case.
part of the matter. But a fruitless exercise on my part, what purpose will be served? Kindly see. They want proof. They want what the last paragraph said of that notice. That is why my question is it a notice or such? This is nothing but the final decision they have taken. They want proof. What proof I can produce? That was already there, placed
No.
with them.
In your reply, page 54,
Yes, Malik.
the second paragraph,
Yes.
you are saying you want to submit your explanation with the supporting documents.
True, my lord. True. Because we are cooperating
But
with them.
What you are saying is 1 week time is not sufficient.
Yes.
So please give us 30 days time.
Yes.
So we'll give you 30
But
days time
orally-
with effect from today.
Well, it is a fact that they have not deducted as yet, but they have orally when we met, because this is a regular transaction. We are always in touch with them. At any time they say that they will deduct it. They will deduct it because it is in their hand. My concern is, my lord, we have, with a view to cooperate with them, we have said this.
No, what this court is proposing,
My lord.
with effect from today,
Yes.
this court will grant you 30 days time.
Yes.
All right.
Yes.
You submit your reply, and till an order is passed, there shall be no deduction.
True. My lord, the only thing is, lordship may add something little more. The documents which we initially submitted to them, they may provide us photocopies of those. Because return was sent immediately along with the challan in the reverse side. Reverse side. If they have already verified it, let them provide us copies of those.
That this court need not say. I think if you ask for
We
it,
will ask for it, lordship may say, they may consider and grant copies to us. So that effective reply, my lord, kindly see what I am asking for. My reply is not just a customary reply, but it must be effective reply. Unless I can see those documents, you are the custodian, you are keeping everything. Every day transaction is going on from then today also, everything is going on. And this thing repeats, every day repeats. You have your own paraphernalias, people to look into and verify, grant credits, you do it. Now you throw the blame on me. You give us proof. Oh, sorry, where from? That is where my case is, my lord. You ask us to give us proof. Well, you granted with a proof.
Let them file their reply, my lord. The only thing, my lord, my learned friend was saying we may deduct it anytime. We could have done it, my lord, at any point of time. And in the pleadings, my lord, subject to correction, I do not find anything that, my lord, they have written again to, my lord, deduct the account. There is no question written, my lord, it could have been deducted. And there is no pleading. Subject to correction, my lord. The only thing, one sentence written in page 16 at paragraph 13 is that the petitioners apprehend imminent danger of recovery by deduction as threatened in the impugned show cause notice. So, my lord, till the reply is given by them, there is no question of, my lord, deduction. And
My lord, orally, what they said, we have made a statement, paragraph 5. Paragraph 5. Lordship will see. However, we said that the petitioners beg to state that individually on receipt of the so-called notices, the petitioners requested for extension of time of 30 days to reply on 22 to 2025 and on other dates. However, on submission of such applications of extension of time, the respondent number 4 refused to extend the time as sought for and uttered to pass the appropriate orders for recovery of the amount as indicated in the so-called notices. Hence this petition. So they have not said anything on return. They have not said anything. They said we will be deducting it.
Okay. Heard Mr. K.K. Mahanda, learned senior counsel, assisted by Mr.
O.P. Bhatti.
O.B. Bhatti, learned counsel for the petitioner. Petitioners also heard Mr. M.K. Chandra, learned senior counsel, assisted by Mr. R. Go ahead. For the, you are the standing counsel or for the respondents. Oblique. Okay, for all the respondents. Stop. For the petitioners are sole proprietors as well as partnership firms
Partnership firm, sole property.
for sale of liquefied
Distributorship.
petroleum gas.
Yeah, for distribution of liquefied.
Within bracket LBG, known as within inverted comma Indian. In stop. Para. No, continue. The petitioners before this court are aggrieved with the is it a show cause notice or is it with the notice? With the communications.
Yes.
With the communications dated 18 to 2025, comma
different dates, one.
18 to 2025 and some other days, some is 11 to 20,
no,
13 to
13 to
They could
2025,
not have joined in a
13
single
to-
petition. They could not have joined in
Yeah.
a single petition.
18 to,
comma 14 to 2025,
yes.
and 18 to 2025 issued by the DGM within bracket
DGM, plant, yes.
not Guwahati. Whereby where it is stated that a review was
Yeah,
that the plant had a review of the credits oblique debits passed to distributors oblique transporters on account of market return cylinders in the year 2023-2024. Which was carried out for the North Guwahati deep stop. in the said review, it was revealed that the credit has been passed to the petitioner's account for empty cylinders returned to the plant, which is equivalent to 1.99 MT of LPG. Is the amount the same?
No, my lord, amounts are different, my lord. Your lordship will see, my lord, case 30,
Of different amounts?
different amounts and different dates, my lord, how?
Amounting to different of LBG.
Yes.
And the said credit was incorrectly passed
Incorrectly
into
passed.
the petitioner's account, comma, since the ARV slips were not signed either by the transport oblique distributor representative or by both. Stop. The petitioners were accordingly directed to submit their explanation within bracket with proofs oblique documents within 7 days as to why the debit oblique deduction should not be raised against them. Stop. Being aggrieved. Stop. On receipt of the aforesaid notices
Communication.
or communications, the petitioners made their separate replies
My lord,
on different dates, correct?
different dates, my
Yes.
lord.
Which is one of those
My lord, page 54 onwards, my.
on different dates before the Deputy General Manager within bracket plants, not Guwahati, requesting for extension of time to submit an effective explanation with supporting documents. Stop. It is the case of the petitioners that the respondents are yet to respond to the requests made by the petitioners. And they're expecting, and they're expecting that the authorities would be deducting the amount specified in their notices, in these separate communications. Stop. Hence the present petition. Stop. Para. Mr. M.K. Chowdhury, learned senior counsel appearing on behalf of all the respondents.
My first submission is that, my lord, a joint petition could not have been filed, my lord, the petition is documented. That your
Submits
lordship may record.
that the petitioners could not have filed a joint petition inasmuch as
Cause of action for
The-
everyone is different.
the cause of action for all the petitioners are different. Para. Stop. He also submits that the that the respondents are yet to deduct the amounts deduct the amounts specified in the separate communications and are awaiting the reply of the petitioners. Stop. Para. Considering the submissions made by the learned counsel for the parties, this court proposes to dispose of this writ petition, directing the respondents to give an extension of 30 days with effect from today. Stop. Thereafter, comma,
To file their
the
individual reply, my lord,
petitioners
individual.
may file their individual replies before the concerned authorities within the said extended period. Stop. the respondent authorities may also supply any documents that the petitioners may ask for in, that petitioner may ask for stuff
To enable them to submit their plan.
to enable them to submit their respective replies, stuff. Para. Till the reply is filed within the stipulated period of 30 days with effect from today. And a decision is taken by the concerned authorities. It is made clear that there shall be no deduction of the amounts specified in the various, in the three communications issued to the petitioners. In the three communications dated 13 to 2025, 14 to 25, and 18 to 2025. With the above observations and directions, petition is disposed.
Lordship may say that within 30 days, we will provide, we will submit our, and
Reply.
they will decide it,
Hmm.
and until then, they should not go for deduction.
That's what I'm saying. Till they take a decision.
Yes.
Till they take a
Yes,
decision,
till they
there
take
shall
a
be no deduction.
They'll give us document, it will take
And
time.
if necessary, they may give us personal hearing also.
That is up to them.
Yes, they can give us personal hearing also. We can sit together and find out what is the wrong there.
While considering the reply. made-
60, total 67%.
Yes. In
Oh,
one group,
oh,
same
while
issue.
considering
Dates
the
are different, issues
reply
same.
made by the petitioners. The respondents are at liberty to give a personal hearing to the petitioners.
Obliged.
All three will be the same order,
Yes, yes.
same order.
Same order. Let the date of notice, we have indicated in the index itself,
Hmm.
13, 14, 18.
Same dates.
Same. And in one, it is my lord, 13, 18, 19, 20,
Okay,
24,
then
28.
1 minute. In item 3,
Yes. In index, lordship will
it
find.
will be 13, 14, 18. Huh?
Yes.
That is- No, no.
60 days.
Item 3 is 1458. Oh, item 3 is 13 to 2025, huh? 18 to 19 to 22, 24 to 28 to and 1 3.
1, 3.
Okay,
Yes.
then item number 2 will be 13, 14, 18.
Yes.
And item 5 is
13, 14, 18.
13, 14, 18,
18.
19, 20, 24, 25, 28. Correct?
Yes. Develop.
6,
May please allow.
Yes, please.
Lordship, here, there was serious complaint of misconduct against a private respondent who was a workman of the petitioner's company. So the complaint was made to the general manager of the company. So by the supervisor as well as the other co-employees. Then the general manager issued a suspension letter as well as a charge sheet and a show cause notice. Finding unsatisfactory, the departmental proceeding was initiated. In the meantime, the workman, not revealing the fact that DP has been initiated, went to the consolation officer saying that he has not been allowed to join office illegally. So, but however, it was intimated that the DP has initiated, so that process, consolation process was kept pending. In the meantime, the departmental proceeding proceeded, evidence, cross-examination of both sides were taken, and seeing that the evidence were highly tilted against him, he filed a writ petition saying that the consolation process is still pending, without revealing the fact that it is almost the evidence has been completed in the DP. So on the first day itself, without issuing notice to the management, the petitioner's company, this honorable court directed that the consolation proceeding may be completed. Now thereafter, the inquiry report was sent to the competent authority, who is the MD. Before that, the MD was not even part of the framing of charge, show cause, anything, or even the evidences adduced in the DP, the MD was not a part. It is only the co-employees who were given evidence in the department proceeding. So MD, after serving notice to him and providing the copy of the inquiry report, then and independently assessing the evidence, came to a finding that the inquiry report is correct, and accordingly he was terminated from service. Now, after that, he files a contempt petition saying the direction of the first writ petition asking the conciliation process has not been completed. Accordingly, the labor conciliation officer frame a reference whether the charge, the framing of the charge is correct or not, whereas the entire process has already been completed. Seeing that the contempt petition was closed, then he filed a writ petition challenging that reference. But ultimately, he withdraws the writ petition. That means the reference is now, he is bound by the reference. But however, he has not challenged his termination and the award of the DP. So he files a section 2 petition before the labor court. However, labor court closes the proceeding saying it is at your behest that the proceeding has already reference has been said. So this court cannot go in this, decide this termination. So they closes it. Rightly or wrongly, that proceeding was closed, but he never preferred any appeal or writ petitions against that closing. So he is also bound by that. So he cannot challenge the termination order anymore. In the reference now, before the industrial terminal, the entire proceeding after filing of WS by both sides, evidence were adduced. When the cross-examination of the management was pending, because the management has adduced evidence, the workman has also adduced evidence and he was cross-examined also. He filed the one-line petition saying the MD's evidence is vital, therefore he needs to be summoned, without disclosing any reason whatsoever for what kind of evidence or for what is the reasons his evidence is necessary. Because that is very vital. That is, as per the CPC, that has to be reason and the court has to apply his mind. Otherwise, court every application, they cannot call for a court witness. And on the same date, without hearing the management, the court passes an order. First, your lordship may see the application at page 173.
Yes.
Second paragraph, that the managing director, so-and-so, Sri so is necessary and vital and relevant witness for just and proper adjudication of the above noted case. But why his evidence is relevant or necessary, there is not even a whisper. And the labor court passed the impugn order at page 66.
Page
66. On the same day.
again, in terms of this,
Is this application?
page 66.
Yes. The application was made on February 25. The order was passed on the same day without giving us an opportunity for objection. If your lordship see the second para, also seen petition number so-and-so filed by the workman praying for calling so-and-so as vital and relevant witness. He has not disclosed any reason as to why his evidence is necessary or for what purpose. It is only after reflecting that the court has to apply his mind and call for. Even the court has not recorded any reason for calling him.
Yeah, you could have taken that objection before the tribunal.
Yes, but objection was not even provided on the same date. Your lordship is
both counsels were there.
Aware that the copy was not served to us. I have made a statement. And they were not even heard. Even if your lordship see our objection also, if any was not recorded, but we were not given any opportunity for
No, first line says both the counsels are present.
because that there was a fix for cross-examination of the management witness, our witness.
Okay.
So we had given a petition for seeking adjournment and we came back. And this petition, we are not even served copy. We came later on after seeking the record. We are not even given opportunity to even file objection also. So on the same day, he passes a one-line order without recording any reason. We could have very well given reason, but now we cannot review because there is no power of review of the industrial tribunal. So we cannot file a review application also. That is why we are before Lord. If your lordship see, this application was filed on 28th May, page 173, 28th February. Last page on.
Yes.
Last verification, I have signed this on 20th day of February. The order was passed on the same day. The application was filed and passed on the same day. This regard, if I just may place one judgment, there are other judgments also from Delhi High Court, Kerala Supreme Court. Just one, this might help. Does this notes the Supreme Court judgment? Because there has to be recording of reason as to why, because otherwise the court says it's a vexatious petition, just to harass the witness. Okay. My copy. I have given 2 copies.
Okay.
The first paragraph says, Your Lordship, there was the order passed for summoning of the witness. And the paragraph 4 states that the violation of the order 16 rule 1 and 3. If I may read, Your Lordship, paragraph 6.
Yeah.
Paragraph 6. The learned counsel for the petitioner cited the decision of the Honorable Supreme Court in so and so to substantiate the point that while summoning the witness, a party has to disclose the relevancy of the evidence with regard to the issues arising in the suit. The learned counsel also relies on the decision of the High Court of Jammu and Kashmir, in which it is held that for the purpose for summoning the witness is to be specifically stated, and it is necessary requirement. And in the absence of such requirement, the court has disallowed the summoning of witness. The finding of Lordship at paragraph 9. Admittedly, during the pendency of the suit, the plain schedule premises were so and so. Order 16 rule 1 and 2 mandates that a party who is desirous of obtaining any summons for the attendance of any witness shall specifically state the purpose for which the witness is summoned. Exhibit is the list of witnesses. No documents are sought from. Application for the purpose of and rest. Then ultimately, Your Lordship, paragraph 12. They set aside that order of summoning the witness. I find that Exhibit 2 order was passed by the trial court without ascertaining the purpose for which the witness is summoned, as mandated under Order 16 Rule 1 of CPC. And Order 16 is unsustainable as far as related to witness number 1. The other judgment, this relies on the Supreme Court.
Anybody for the reason?
Madam, may kindly come to page 66.
Yeah.
Where also I am appearing for Exponent 1, 2, and 3 Lordship. Otherwise, the judgment which was relied, there is no dispute. Lordship. Reason should be there for calling of the evidence. Otherwise, the order itself says that Lordship. Page 66.
It was fixed on 4/3/2025.
Yes.
The witness appeared.
No, we have taken adjournment on that day because we had to file this petition. Because if
There was also Lordship. Madam, may kindly paste this order Lordship. The learned counsel of both parties are present. Seen the petition bearing number 2125 filed by the management. This was filed by the management Lordship for adjournment of the course of examination of management witness Lordship. And other petition was 25/2025, where the complainant sought for Lordship calling for the management witness Lordship. The petitions which was filed by the management Lordship 2125 is not annexed here Lordship. We don't know Lordship what is the context of the petition Lordship. Whether he can that petition.
that petition,
Lordship, he
that's
can-
MW1.
He can.
That is not a court witness. That is not a court witness. That is MW1.
Otherwise, the petitioner in that particular case sought for the management witness, calling for the MD of that particular case Lordship. Whether in respect of that petition, so other petition today we don't know Lordship. So he may place it, otherwise next date Lordship may pass the order on the basis of the.
Your Lordship, I may clarify, I will give a statement to this. They have adduced evidence. The workman has given evidence. As a workman evidence, he has cross-examined. We have also given evidence because the general manager was involved in the issuance of the charge sheet, show cause, and during the entire TP. So he has adduced evidence as management witness, and it was for his cross-examination. Since he was not well, so we had asked for adjournment. So here they have called the MD who is the competent authority. Now your lordship see the precarious situation here. He is the reference he has challenged, then withdrawn. So he is bound by the reference. Termination order he has challenged, then that was closed and he has not filed any writ petition against that order. So the termination order was passed by whom? By the MD as a competent authority under the standing orders.
But R. Sharma, Learned Counsel for the petition. Notice will have to go to issue notice. Mr. K. Gugoi, Leonard, additional senior governor.
I'm for 120 also.
Appears for the respondents, 1, 2, and 3. Stop. Extra copies. Petitioner to take steps for service of notice on the respond number 4 by registered post AD. Yes. Within 1 week. List of the 4 weeks. Para. Till the next returnable date. Further proceedings of reference case number 05/2020 in the Leonard Industrial Tribunal Assam shall remain suspended.
Must apply.
Seven.
May I please? And this is a matter of second order of litigation, matter. The petitioner is a cooperative society, matter. They in the 2015, matter, the petitioner matter applied for PDS license, matter.
What license?
PDS license, matter.
Okay.
Yes, matter. Then matter, thereafter nothing was happened, matter. The petitioner approached this honorable court in the year 2021. Admittedly, there is a delay, matter, for approaching this court, matter. That's why matter, this court matter allowed the petitioner to apply fresh, matter. So accordingly, matter, on 3/2/25, the petitioner again applied for PDS license before the district commissioner, matter, or district, matter. But nothing has happened till today, matter. So my limited prayer is that, matter, the district commissioner, matter, made.
Where is this order 310?
Yes, matter, page 19, matter. Relevant portion is my page 20. In page 21, liberty was given to us, matter, to prepare and phrase application, matter.
Up to this, you applied when?
Again, matter, on page 36, matter, we have applied phrase, matter. The type copy, matter. Photocopy is at matter, page 38, matter.
$36.
Yes, matter. This is a type copy of the matter, phrase application, matter. The original is at page 38, matter.
So what is your play now?
Nothing has happened, matter, as yet, matter.
This application has
No action has been taken as yet, matter.
not yet considered.
Yes, matter. That's why, matter, I have.
Yeah.
Before your lordship.
This was filed on 3/2/25. Otherwise, Lordship may dispose of with a direction to the authority to consider as per law and existing policies, Lordship.
3/2/2025.
Recent.
They will require some time to consider.
Recently,
it.
yes.
On the last occasion, they came lately, matter. That's why, matter.
Heard, Mr.
Yes, matter.
Yes, protocol and the council. Also heard Mr. K. Gugoi, Leonard, additional senior governor. That's it. Appearing on behalf of
Lordship, I am for 1 to 4, Lordship.
1 to 4. How about cooperative society? And MS? SG? But
I have 7 also. I am
standing council appears for the respondents. No, the standing council cooperative department, huh? Appears for respondents 5 and 6.
I am for 7 also.
Oh, 7. Gay Google, yeah? 1 to 4 and 7. Stop. The petitioner is a cooperative society. registered under the provisions of the Assam Cooperative Societies Act 2007. Stop. Draft a comma. The petitioner met an application for issuance of a PTS license, which was in the year 2015.
15 minutes.
So, however, comma, as no steps were taken, petitioner approached this court by filing WBC number
6514/21.
6514/2021, which was disposed of on 3/10/2024 with the following observations and directions. Para 5 to 7, page 21, 8A, stop. Para. Pursuant to the order dated 3/10/2024, passed by this court in WBC 6514/2021, the petitioner met an application before the district commissioner, South Salmara Mankacha, Hatsingi Maria, on 3/2/2025, with for issuance of a PTS sub wholesale oblique dealer oblique retail license in favor of the petition. Stop. The grievance of the petitioner in the present petition is that his application dated 3/2/2025 is yet to be considered by the respondent number 3. Respondent number. Para. Considering the short period involved, comma, this writ petition is disposed of, directing the district commissioner, South Salmara Mankacha oblique respondent number 3, to consider and dispose of the application made by the petitioner on 3/2/2025 in accordance with law within a period of 1 month.
6 weeks, Lordship.
Within a period of 6 weeks from the date of receipt of a certified true copy of the order of this court.
Also may indicate existing policy also, in accordance with law and existing policy.
In accordance with law
And existing
and
policy.
as per existing policy.
Lordship.
With the above submissions, the petitions.
Item 8, stay vacating application.
Lordship, in this matter, Lordship, I filed the IA Lordship for getting the modification of the order. Lordship, in the main case, Lordship, the government has filed, that the department has filed an affidavit, Lordship. And the reply of the petitioner has also been received by me, Lordship. I want to file a affidavit, Lordship, in the main case, Lordship. And Lordship, may thereafter hear the matter.
Lordship, the problem is this, Your Lordship, they are going ahead with the work, Your Lordship. Ultimately, this petition will become infrastructure in spite of there being a status quo order, Your Lordship. Initially, they stopped it, Your Lordship. Thereafter, what they did, Your Lordship, they took advice from their council, Your Lordship, and on the basis of that, since status quo order is in their favor, Your Lordship, they can continue with the work, and ultimately, this will virtually become infrastructure. If Your Lordship at all want, Your Lordship, may be taken up on 19th, Your Lordship.
How long will you take?
Lordship, I pray for 10 days time, Lordship.
By that time, Your Lordship, virtually work will be over. They are continuing, Your Lordship.
Then I'll give you a week's time.
Lordship,
By Monday, I'll take up.
Lordship.
next Monday, Lordship, I will be
Lordship.
filing.
You want to file reply in the,
I want to file an affidavit in the main writ petition, Lordship, and one more, Lordship, that
the
I have
what affidavit?
affidavit in opposition, Lordship.
You have 40?
I have not filed. I am for the respondent number 5, Lordship, who filed the IA, Lordship.
Okay. So I notice has gone.
Yes, Lordship.
So,
We have also filed objection.
And Lordship,
so I we are keeping it open.
Lordship, keep it open, Lord.
Okay.
Lordship, and one more thing, they have filed an additional affidavit with some statement on 7th February, Lordship, which is not with us. So they may kindly furnish us this copy, Lordship. Otherwise, affidavit cannot be prepared, Lordship.
Okay, heard as brought up and also for the petition. In the writ petition. Stop.
No, good bad.
MS M Bhattacharya. Bhattacharya. learned counsel appearing for the respond number 5
Lordship.
is allowed a week's time to file a counter affidavit. Stop. List the matter on
On 24th, your lordship.
24th March.
Lordship.
Lordship can.
In the meantime, comma, the petitioner's counsel shall furnish a copy of the affidavit
Additional affidavit.
of the additional
70
affidavit
Lordship.
filed on, where's the additional affidavit?
Lordship, this is
That
given
has
the
not been
record,
kept,
Lordship.
not in.
Filed on 7/2025 to the learned counsel appearing for the respond number 5 within today. Within the
Did
court.
we apply?
Mr. P. Nayak, learned standing counsel appears for the irrigation department.
Deeply obliged.
Obliged. Your lordship, another item is there, your lordship. 65, your lordship, both may taken up together, your lordship, on that day.
Item
65. That case is, pleading is complete, your lordship. There is no IA, your lordship.
the other parties.
Your lordship, I'm for responding number 7.
Oh,
Lordship, it may be taken.
all together. Okay.
Together, your lordship, on 24th, your lordship.
Item 65 on request made by the parties. Release the matter on 24th along with WBC number
WPC.
Item number 8.
651 of the 2020.
Interim orders will continue, your lordship.
Where?
Both
One
the cases,
status
your
order.
status code.
On top, interim order passed earlier to continue, both cases, sir.
Deeply obliged.
Nine and 10.
Please, your lordship. We will file in the objection in this reply
Oh.
to their application for modification variation of the order. 1. Second, we have filed an IA bringing notice to the court about regarding an NOA which has been issued in favor of the private respondent and which was mentioned in our writ petition. At the relevant time, when we moved the writ petition, we told the court that it is not with us. But we made a statement to the effect in the writ petition that notice of award was issued to the private respondent on 14th of January 2025. So we want to bring notice to the court by filing an IA. No? Additional affidavit. And secondly, thirdly, we have filed an application for amendment of the writ petition so the prayer is concerned regarding an NOA, which was not in the earlier writ petition, the part of the prayer. So these 3 things we have filed today in the morning, which has been served to the other side. And
Not sir.
not
Amendment, application for amendment has not been.
amendment is
These
in
are
the process.
delaying tactics, my lord.
Amendment is in the process. So whatever may be delay or not delay, if your lordship want to hear and reject it, your lordship will reject it. But we are on record.
We are not rejecting,
Yes.
my lord. We are on not extending.
Yes.
What has happened, my lord? On 14th of January, the work order was already issued. They simply make a statement in the writ petition without bringing it to the notice of this honorable court. And they take an interim order that work order should not be issued. And this blanket order, it was a common NIT for Ahmedabad as well as Assam. Total of 14 plus 24, that adds up to 38 units is concerned. They put a challenge to only one of the selections made, and they take an interim order without a challenge to Ahmedabad. There is a blanket. If your lordship will kindly come to the interim order. It's 31.
In the writ petition.
In the IA, man. Your lordship will kindly have the IA. Page 31 of the IA. Paragraph 8.
1 minute.
This is IA number 666 of 2025.
Yes.
Your lordship will kindly peruse the last paragraph, paragraph 8. Till the next date fixed, the ONGC authorities shall not proceed to allot the work order in respect of NIT dated 6/6/2024 for hiring of scrapping wage for Assam and Ahmedabad assets for a period of 5 years. Nothing, your lordship will kindly have a look at their prayer. Nothing is under challenge. They come, do not disclose to this honorable court that 1 month back work order, your lordship will find the work order at, your lordship will kindly see the work order, page 23.
This interim order is dated 12th of February. And on 23rd itself, on 14th of January itself, the work order was issued. This aspect is never brought to the notice of this honorable court. And that is why there is no mention of this. And this is not even, your lordship will kindly have a look at their prayer matter. This is not even under challenge. And an entire tender process for the Ahmedabad as well as Assam assets for 38 units of scrapping winches has been brought to a grinding halt. Why will your lordship permit such a thing? Time and again, Supreme Court has said that in these kinds of matters, your lordships will be very, very circumspect. The entire tender process for the two assets, Ahmedabad and Assam, are put to a stance. Therefore, my lord, my respectful submission is let them file whatever they want to file. They file, if this is not delaying tactics, what it is. This is the size of their objection. For a 20-page affidavit that we file, simple issue. You have taken an interim order by suppressing the work order without bringing it to the notice of this. This interim order itself is infractuous. If your lordship sees the interim order, not to proceed to allot the work order has already been issued. So what remains in this? So therefore, my lord, my respectful submission, whatever they want to file, let them file. But this interim order should not be extended any further for the simple reason everything has been brought to a grinding halt. And your lordship will kindly see the petition, my lord. There are about 28 people who have been selected and work orders have been issued. And if your lordship kindly sees the writ petition, your lordship will kindly come to the cause title. Your lordship will come to page 5. Man. Respondent number 5 is the only private respondent. There are 27 other selected parties. There is an interim order in respect of them all. There is no challenge. And if your lordship kindly comes to the prayers, your lordship will find that this work order is not even under challenge. So if they have filed an application for amendment, they are themselves admitting that this is a defective writ petition. So there cannot be a question of an interim order being continued in a defective writ petition. So my prayer today is, your lordships will not extend the interim order. And because in the meantime, work orders have already been issued, and these parties are skeptical for mobilizing their resources. Or at least your lordship will make it very clear that there cannot be any interim order in respect of the others. Otherwise, we are facing a very serious situation, my lord. The ongoing contracts are coming to an end.
How many
total selected parties are 28.
28.
No, because Ahmedabad is also involved. For Ahmedabad asset, there are a total of, let me just make the position clear. For Assam, there are 24 units. And for Ahmedabad, there are 14 units. So this respondent number 5 in the writ petition has been selected for only 10 units. So remaining 28 units are not with the respondent number 5. So in any case, for those 28, there cannot be an interim order. That is number 1. Number 2, even in respect to the respondent number 5, the work order itself is not even under challenge till today. We filed the IA putting on record, and they know about this fact. They have made a statement in the writ petition that 14-1 work order has been issued. They simply make a statement in one remote corner of the writ petition without bringing it to the notice of this honorable court, and they take an order that work order should not be issued. And we filed this IA as far back as on 4th of March. Till today, the writ petition has not been amended. So by their own admission, it is a defective writ petition. If they are filing an application today for amendment, it is an admission of the fact that it is a defective writ petition. So there cannot be a question of an interim order in a defective writ petition. So my respectful submission, my lord, this interim order may not be extended.
I'll tell your lordship one thing. My learned friend has first said there is a separation of material fact. We got an order from the court without giving any without the court knowledge of 14th of January 2025, the NOA has been issued. That's what he said on the first point. Kindly look into it, my repetition.
I'm admitting.
No,
But in the order, it is not reflected.
Yeah,
In the order, it is not reflected.
I didn't disturb you. Please don't. Let me put my submission now. My lord will kindly look into paragraph 20. Kindly see.
That I have said.
See paragraph 20. You didn't say on the first point. See paragraph 20, my lord.
Page 31.
Page 31. Kindly see, my lord. Next page. 31. First on the top, first, second, third, fourth, fifth, sixth, seventh, eighth line. Kindly see 8th line at page 31. Now, pursuant to the opening of the financial bid in respect of the NIT dated 6/6/2024, it has come to the knowledge of the petitioner that notice of award has been issued to the respondent number 5 on 14/1/2025, but no work order or contract has been signed with the respondent number 5. Further, the respondent number 5 has not started any mobilization work. Thus, the respondent number 5 has not commenced work. Further, though notice of award has been issued, but an extension has been given to the existing contractors, including the petitioner, for 4 months, for which the respondent number 5 cannot start mobilization for commencing work. Accordingly, interference with the tendering process pertaining to NI and dated 6/6/2024 will not prejudice the respondent number 5. Now it will affect public. Not will now, we will. So this is what we made a statement in the court while moving the writ petition. What is about the case? It is very easy to tell the court that this order should be vacated. This is not there. That is not there. What is the merit of the case? If you really want to argue, I am ready to argue.
Yes,
but on record, I have brought their the objection, their application for modification variation will not be taken into account. Then there is no problem for me, my lord, because I have brought notice by filing a reply to their application for vacating of the order. By mere saying that this order should be vacated. On what ground it should be vacated?
On this
One, on what is the merit of the case? Let us see.
I did not want to go that far.
No.
Your Lordship will kindly come to page 30
No,
of the
please,
IA. This is the submission, misleading submission made. However, it is submitted by the respondent authorities are proceeding to allot the tender in respect to the respondent number 5. Mr. Das therefore submits that interference of this court is necessary to restrict the process undertaken by the respondent authorities for allotment of the tender in respect of the respondent number 5 who is not clearly qualified. In the writ petition, they make the statement, but in the court, they may say that allotment has not been made.
But
this is a submission recorded in his mouth.
But that is not, I have not written the order. I have not written the order.
Whatever
it is that I have written
His
the order.
submission is recorded.
Yes, my submission recorded by the court.
Whatever it is.
Yes,
whatever it
don't
is,
say the word misleading. It is on the record at page 31. Maybe.
Court has passed an order.
Yes.
Right. Court has passed an order.
Yes, court has passed the order.
So,
my lord will, if your lordship is willing to hear it, on their IS should not be taken and let it be heard on the basis of the writ petition which has been filed. Why technical commercial bid, how it has been allowed, it should not be allowed. It is only for the purpose of benefiting the respondent number 5 they have done it.
are you challenging this NOA?
Yes, by an IA, we have brought into notice before this court.
Additional affidavit
Yes,
you have filed.
yes.
No prayer.
This is there. Then we made now an amendment application, amendment for allowing the amendment for inserting that the prayer portion of the NOA. We have brought notice to the court today. It was not with us. It was not with us, the NOA.
No, but then you've made a statement in your writ petition.
Yes.
That the 14/1/2025
Yes.
NOA was issued.
Yes,
Correct.
that's yes.
That you could have challenged.
No, that is what we are bringing notice to the court
Now.
by filing. Yes, now.
In the writ petition, first writ.
No, that was not with us. The NOA was not with us.
You knew that was there, is it? Because that's
2025 was, we knew it. That's why we made a statement. But
since you knew it,
yes,
you could have made a challenge to that.
no,
also
we have
in the
made,
prayer.
now we brought it now by Lord, allowing the amendment before the court. There is a writ petition. Kindly see the prayer of the writ petition.
That I'm on
Yes.
that. I'm on
Yes.
that page.
Yes. Kindly see the prayer of the writ petition.
NOA is
Yes,
not
38.
on-
Now
not on-
I'll-
not
I-
on the challenge.
No, I'll tell your lordship, my lord. your lordship will hear it. If that be the case, your lordship will hear my writ petition on what ground an interim order has been passed by this court. These are all consequential order, the NOA. Suppose today, your lordship is satisfied that techno-commercial bid should not have been allowed in their favor in respondent number 5. That's consequence to that the NOA will go. My lord, I have challenged the techno-commercial bid of the respondent number 5, which was allowed by the ONGC. That's
Okay.
my basic ground. Now, on the basis of that, my lord, NOA has been issued. Now, I have shown, demonstrated to the court that how a techno-commercial bid was allowed in favor of the respondent number 5. It could not have been allowed. If it is not allowed, then NOA will go. Let me project before your lordship that what is the case about. Kindly look into the case. See the NIT first, my lord,
One minute,
S45.
just a minute. Yes.
See page 45, the NIT. Lordship will kindly see this NIT which is issued on 6/6/2024. Please note the description of the work. Number 3, description. Hiring of scrapping winds for Assam and Ahmedabad asset for period of 5 years. So we are now challenging about hiring of scrapping winds for Assam, not the Ahmedabad asset. Now, my lord, will kindly see 7. Date of pre-bid conference is on 19/6/2024. Date and time of closing of tender was 16/7/2024. But however, it was extended. I'll show it, my lord. It was extended till last date was 1/8/2024, which your lordship will have a quick look. Find it the extension at page 104. Page 104.
Yes.
See, my lord, at 26/7/2024, then tender closing date and time 1/8/2024. Tender opening date and time is 2/8/2024. Lordship got it? Now, my lord, will lordship again go back to page 45. My lord, just my lordship has
5 minutes.
yes, yes, of course. 4. The lordship has looked into it. Date of opening of the tender was also on 3 that your lordship has indicated in that particular page, which was I was going through that page at page 120. 104, my lord. 104. Your lordship has looked into page 104. Now, my lord will kindly see page 47. I'll show you one clause and then the order passed by this court. See 5.0 at page 47. Page 47.
Yes.
5.0. Deviation, exception, if any, to the provision of the bidding documents shall not be entertained after opening of techno-commercial bid. After the submission of the bids, company may not seek and entertain any clarification, confirmation documents from the bidders or enter into any correspondence with the bidders after the date of closing of the tender. Bids shall be evaluated based on the information document submitted in the bid. Bids not complying with the requirements of the bidding document shall be summarily rejected. Hence, bidders are advised to ensure that they should submit appropriate and relevant supporting documents along with the proposal in the first instance itself, as no further opportunity will be given by the company to make good deficiency, if any. So once, my lord, you file the bid document, what is the scope of the work has been filed by the bidders, my lord. That's, my lord, only there can be a clarification deficient of that particular original scope of the work. It is not that the ONC cannot give an opportunity for submitting which is outside the scope of the, which is not a part of that scope of the work. If the scope of the work, your lordship will look into it. The scope of the work at page 45 is hiring of stepping winds for Assam and Ahmedabad. So only to that extent. So you cannot be supplied with some new documents, which is no connection with the description of the work. That was our case which we projected. Now, if your lordship looks into it, further, I will show the orders, why that order was passed. Now, my lord will kindly see instruction to bidder at page 50. Instruction to bidder at page 50. My lord will kindly see, if your lordship looks into 1.1a, eligibility, A, introduction down below, eligibility and experience of the bidder, 1.1a, eligibility and experience of the bidder at page 50. Kindly see below. 1.1a, eligibility and experience of the bidder. Please refer to technical BEC for eligibility and experience criteria. Please turn to page 51. B did bidding document. Now see annexure 4, bid evaluation criteria. Lordship got it, my lord?
Yes.
Now, if you look into it, I'll show it at page 88 later on. Please look into at page 57. 57, 9.0, 9.12, Roman 2. That the bidder meets all the criteria prescribed in the bid evaluation criteria, annexure 4. Now, if your lordship looks into page 57, lordship got it, page 57? Yes. Lordship has looked into 9.1, Roman 2. That the bidder meet all the criteria prescribed in the bid evaluation criteria, annexure 4. Please turn to page 72, which is most important, and your lordship will please mark it at page 72, 20.1 and 20.2.
Yes.
The duly completed bid with no system error message can be submitted in e-procurement portal anytime before the submission deadline is reached. Bidder shall also be permitted to make changes in his bid and resubmit the same in e-procurement portal till the submission deadline. The final submitted version of bid only shall be considered by ONC. Please mark 20.2. No bid can be submitted after submission deadline is reached. The system time that will be displayed on e-procurement web page shall decide the submission deadline. So lordship will kindly note down the submission deadline was 1/8/2024. That we read that page 104. Deadline of submission of the bid is at 1/8/2024. Now at page 73. 24. Evaluation and comparison of bid. 24.1. Evaluation and comparison of bid will be done as provision of bid evaluation criteria at annexure 4 to be supplied separately along with bidding document against individual tender. 24.2, your lordship will kindly see it. Clarification of bid. 24.2.1. Lordship will kindly mark this also. During evaluation of bid, purchaser may at his discretion ask the bidders for clarification, confirmation, deficient document in his bid. The request for clarification response shall be in writing and no change no change in the price of substance of the bid shall be sort of permitted. So lordship has looked into it. The response shall be right, no change in the price of substance of the bid shall be sought to be permitted. Now, after that, when bid evaluation is done by the authority, then the award of contract is at page 79, 31.0. See 31.0. Purchaser will award the contract to the successful bidder. 31.0 at page 79.
What criteria?
Yes, the purchaser shall award the contract to the successful bidder whose bid has been determined to in full conformity of the bid document and has been determined as the lowest evaluation bid. What we are on, my lord, when you evaluated the bid of the private respondent number 5, we are not on others, my lord. That I am making very clear. We are not on others. We are basically on the private respondent 5. Why his techno-commercial bid was accepted. That's our whole case. So if it could not have been accepted, there could not have been award. So that is the reason why I'm showing at page 79. When the award criteria comes into play, it is only when techno-commercial bid or financial bid is allowed. Then the question of award criteria will come into play. Here, my lord, our whole case, techno-commercial bid A could not have been in favor, open in favor of the private respondent.
5.
Yes, respondent number 5. And we are not, my lord, I am making it a point clear here. We are not on the other respondent.
Who is the order? Entry model?
Yes, no, other respondent, other parties, bidders.
Who is the order passed?
Yes.
Okay.
Now, my lord will kindly look into it at page 80.
See, this para 8
Of
the entry model,
yes. It's
12 to 2025.
yes.
It's a blanket order.
My lord, let me complete it. Then I will show it whether it is blanket or let me complete.
Okay.
Let me complete it, my per submission, my lord. Now, my lord, is at page 80, 30.0,
Which?
80,
Okay.
30.0, signing of contract. Once award is being passed, my lord, there comes the signing of the contract. Successfully required to so and so within the period of 30 days. Now we'll like kindly look into at page 88, which is most important. Bid evaluation criteria, which is annexure 4. How a bid has to be evaluated and what is the criteria. Now, at page 89, please look into page 89. 2.1A-1. Lordship got it? Lordship got it?
Yes.
Bidders, single bidder, Indian joint venture companies should have successfully executed at least one number of contract of minimum 1 year duration for any of the following service during the last 7 years in the oil and gas industry as on originally scheduled date of opening of techno-commercial bid as mentioned in the NIT. This is the, my lord, well stepping, downhole job, bottom hole, so and so. Now kindly see the note. Ongoing contracts having satisfactory completion of minimum duration as above shall also be considered as executed for evaluation purpose. The bidder's experience in ongoing contract involving multiple services with no interdependence shall also be considered in meeting the experience subject to condition relevant service has been satisfactorily completed. To this effect, bidders should submit copies of respective contracts along with the documentary evidence in respect of satisfactory execution of each of those contracts, satisfactory completion of relevant services in the form of copies of any of the document indicating respective contract number and types of service, such as satisfactory completion, performance report, or proof of release of performance security after completion of the contract, or proof of settlement, release of final settlement against the contract, or any other documentary evidence that can substantiate the satisfactory execution of each of the contracts cited above. So this is how you evaluate. These documents will be placed before the authority concerned. They will look into it, whether the bidder is eligible as per the terms and condition of the bid. So your lordship will kindly look into it, recollect and go back to page 49 and see what is the scope of the work. Hiring of stamping wings. So it is only connected with that. You have to give, if you really have done that job, you have to give a copy of the contract along with this ABCD. You have to submit. On the basis of that, this criteria, my lord, bid is being evaluated by the ONGC. Now, if you look into it, now, my lord, see a brief pre-bid conference was held because the bidders wants to clarify themselves to the authorities. What is about the hire of stepping wins? What is the ONM is concerned? So they wanted to clarify themselves. So there was a pre-bid conference which was held Your lordship will kindly look at page 100. See 100.
Yes.
Subsequent to pre-bid conference held on 19/6 for tender of so and so, thereof the reply to pre-bid queries are as under. If you see, this is the party SK Logistics Private Limited. If you see second paragraph, bid evaluation criteria BEC clause, this which I read, my lord, 2.1A1. Bidder, single bidder, so and so should have successfully executed at least one number of, that's what I have just pointed out, my lord. Bid evaluation criteria, what is the nature? What is the contract about? Now, if you see on the next column, pre-bid queries, your lordship on the top, kindly see. Upon careful analysis of tender document, we Messrs. So and so propose bidders' experience criteria be limited as to well stepping, given the technical criteria and know-how, so and so, different so and so, we believe that so and. Now see secondly, additionally, lordship got it? Additionally, we request you to kindly clarify whether the qualifying criteria includes only charter hire services or if O&M, that is operation and maintenance, experience shall also be considered. It is clarified. Kindly see on the next column. My lord, one kindly note down. This operation maintenance is supply of only manpower without any equipments. That your lordship, I will show it. What is that they have given? My lord, kindly see on, it is clarified that the eligibility and experience qualifying criteria is for providing services with equipments. That is charter hire services, not the OM. Now, my lord will, because they clarified, it is not the OM. Now, if your lordship kindly look into it, you can't start the work. You can't start the work because simple reason, because of page 102. Kindly look into page 102, my lord. See 102, mobilization period. See the mobilization period. Now kindly look into as per so and so on the ONC remarks. Mobilization period is to be considered as 75 days from NOA. The same is to be read as 75 days everywhere in the tender document. So even you give an NOA, 75 days you cannot start the work because you get it, mobilization period only will be considered after period of 75 days. So immaterial, whether you get an NOA or it doesn't get an NOA. You can't start. Now I will tell your lordship what has happened. How dare the respond number 5 bid was considered. That was whole basic challenge before this court. His bid, technical bid should not have been considered by the ONC authority. Why they have considered? Kindly see at page 122 now. 122. Now your lordship will say at page 124.
Yes.
124. This is response number 5, my lord, where they have given a certificate. On the basis of that, bid evaluation criteria was considered. But what they want, I will show it by their own document. They said that no, we are giving one more chance after closing date. After closing date, we are giving one more chance to bring notice to the ONC authority because their particular what has happened. See at 124. Name of the work, operation and maintenance. Now your lordship has looked into it. When a query was asked by the bidder, they said they made it very clear. There is no question of operation maintain, only hire of catering. This charter services, not beyond that. Because that was the query that was asked. And they said, no, we can't allow operation maintenance. What the response number 5 has given, see at page 124. Name of the work, operation and maintenance. Brief scope of the work, to supply skilled and highly skilled manpower for operation and maintenance work of so and so work rig at Kaveri asset. Now, my lord will kindly see contract period 18/11/2021 and 17/11/2024. Now, this is a certificate which is given by the Oil and Natural Gas ONGC, my lord. Now, this closing date was your lordship has noted at 1/8/2024. Now, you cannot now substitute by filling up the lacuna or gap which you have which you have done in the instant case and you have allowed. Only clarification, deficient, whatever is there in connection with that scope of the work has to be. Original document, my lord, not beyond that. At page 120, 129, kindly look into it, 128. If you see at 128, my lord will kindly see respondent's shortfall documents. Lordship got it?
Yeah.
Now you see at bidder's name, South Asia Consultancy, which is the private respondent number 5 in this case. Frozen date and time, 8th of October 2024. Lordship, I looked into it. Last date of closing date. Now, if you look into the one description, now bidders, what they have done it, my lord, after that, 8 October, frozen date was 8 October. Thereafter, on 1/8/10/2024. Now, 8/10, your lordship will kindly see frozen date and time.
That is submission date.
That is submission date after closing date. My lord, lordship, am I clear, my lord?
Yeah.
1/8 was the closing date. 1/8 was the closing date, and they have submitted 8/10/2024. What they have submitted? A totally a new document. It is not a clarification or deficient. Annexure 4, lordship will find at page 129. Kindly turn 129, my lord. 129. This is to certify. My lord will kindly see now. This is who has given, my lord? Permian Peak Oil Private Limited. This is to certify that Messrs. South Asia Consultant has successfully completed the LOA number so and so dated 25/2021 towards for provision of hiring and scrapping winches for well scrapping job for our weeks of so and so for a period of 2 years. These services provided from so and so has been found satisfactory. What was the original document you submitted? Original document or the O&M maintenance, if your lordship looks into it, that is operation and maintenance, which in a pre-bid meeting conference, they made it very clear. There is no question as operation maintenance. So now when you submit, giving a new document, otherwise this scope should have been given to other tenderers who did not participate also. You cannot ask someone to introduce some new documents. This was basically our case before the learned a single judge. Now kindly see at page 129, lordship has looked into it. Now see at page 130. This is not a contract. This is a LOA, letter of award. Kindly see subject, letter of award for hiring scrapping, winches for well scrapping job for our well of so and so. So these two documents, my lord, has completely, they have changed the entire scenario. What was the original scope of work and what they submitted before closing date on 1/8/2024 and after that 8/10/2024, they have not a clarification. This is not a deficient. This is something very new you have given, which you did not have earlier while submitting the bid document. And specifically, they have mentioned the authorities that that particular cannot be allowed. Now, if that be the case, if your lordship on the basis, I don't know what will be the outcome of the case. Your lordship will look into the case and then the matter will be decided. But today, if your lordship finds that techno-commercial bid would not be accepted, there is an NOA automatically will go. That's a basic foundation is this is rule. Techno-commercial bid, if your lordship finds on the face of it, it could not have been accepted by the authority. So, what is the outcome of the NOA? Because of techno-commercial bid, you have accepted. Award of criteria, that's why reason I have showed, my lord. You have, the bid was evaluated by the ONC authority, keeping in mind about BE 2.1.A, saying this is what a criteria has to fulfill, a contractor has to fulfill, bidder has to fulfill. What you have to give? The services of higher stepping winches. You have to also provide the contract. You have to also complete the completion, whatever it is written there. Where is that? You have not provided. You only have provided what? operation and maintenance, which has no connection, is supply of only manpower. And what is, suppose today your lordship interferes with this. For a moment, your lordship interferes, NOA goes. Consequent to the NOA, he will go. So this is what my lord projected the case before this court, and lordship will kindly look into it. Now I will go through the interim order what was passed. Your lordship is looking into that order and saying that we should. I will also read along with that interim order that was passed by this court. My lord, I am making it very clear. When this matter was moved, we were only agreed with the Assam asset, nothing to do with Ahmedabad asset. If your lordship wants that Ahmedabad asset that should be modified to the extent, we have no problem, my lord. More Ahmedabad asset. We are not against any other contractors. We did not. What we are against this private response number 5. How is techno-commercial bid was accepted by the ONC? We are agreed by that. And for your kind information, my lord, I will just put it one word. All this, the other bidders, all their particular has been work has been extended because those are the existing contractor along with me. Up to May 2025, it has been extended. And what was the occasion? My lord, the private respondent bid was expiring, bid validity period on the day. He doesn't want to extend. Hurriedly on 14th of January 2025, they have issued the NOA. Only to him. Why not to others? Others already have, my lord, work order has been extended till May 2025. They are the existing contractors. I am also existing contractor. Why to the private response number 5? That's the reason why we made the private response number 5, that he should not have been technically qualified. Now, my lord, I will show law has changed now. NG project, there's some Monte Carlo, and all those cases now has been diluted by a later judgment. At one, your lordship now, I'll show one judgment. Techno-commercial bid also is found that somebody was given at the award. Contract has been signed. Even the Supreme Court has interfered. We'll set aside that order. This I'll show it, my lord. Now my lord will kindly see. Let me read the order of 12th of February 2025. 3, my lord. Submits that by way of notice inviting tender published on 6/6/2024, the Oil and Natural Gas Corporation invited bids for work, hiring of stepping winch for Assam and Ahmedabad asset for a period of 5 years. The relevant date for receipt of queries for pre-bid conference, date of pre-bid conference, date and time, closing of the tender, and date and time of opening of the tender were specifically mentioned in the tender. It is submitted that the date of opening and closing of tender is specified in the NIT dated 6/6/2024 was subsequently extended. The petitioner is a contractor who has executed several works for ONC authorities, including rendering services for the hire of stepping winch for his oil wells as when required by the ONC. By referring to the bid evaluation criteria specified in the NIT, learned senior counsel for the petitioner submits that the bidder has to successfully execute at least one number of contracts with a minimum of 1 year duration in any of the services during the last 7 years in the oil and gas industry as specified under clause 2.1A1 of the bid document. Learned counsel, senior counsel petitioner submits among the various was prescribed under clause 2.1A1 of the bid document, well stepping or in the nature or is the nature of work for which the present bid has been called for. He further refers to clause B.1, which specifies the vital technical condition which are to be strictly complied with, failing which the bid will be rejected. Mr. Das, learned senior counsel petitioner also refers to various queries raised by some of the bidders in respect of tender condition and a remark issued by the ONC. Subsequent to pre-bid meeting which was held on 19/6/2024 and a discussion held thereafter, remarks made by the ONC in response to the queries of the bidders as seen in the extract of the minutes of the pre-bid meeting reflect that the ONC has remarked the eligibility and experience and qualification criteria for providing services are related to the equipment and not to the operation and maintenance services. Mr. Das therefore submits any document or any credential furnished in respect to operation and maintenance experience are not to be considered for allotment of the present work. Mr. Das refers to the certificate of satisfactory execution of running contract issued by, to the respondent number 5 ONC in respect to the work executed for ONC for another contract. He draws the attention of the court to the scope of the work referred in the said certificate to submit. The scope of work indicates that it is for supply of skill and highly skilled manpower for operation and maintenance work at Kaveri asset maintained by ONC. It is submitted. Document furnished by respondent of 5 reflects that the experience of respondent of 5 is in respect of supply of manpower and maintenance and not in respect of operation of hiring of stepping winches. Mr. Das also refers to the extract from the portal dated 6/6/2025 to submit that shortfall documents were submitted by private respondent on 8/10/2024 in support of his experience, which is well after the tender closing date. He submits that as the date specified in the NIT, tender closing date, although initially was 16/7/2024, it was subsequently extended to 1/8/2024. He therefore submits that it is not permissible and the ONC authorities ought not to have permitted the private respondent number 5 to submit document in support of its experience after the tender opening date. On this count itself, the bid submitted by private respondent number 5 ought to have been rejected. So if on this, pausing for a moment, if your lordship finds on record that this is neither clarification, this is neither deficient, it is only to fill up that lacuna. They are giving a new document, which is not permissible. So on this ground itself, it should be is a ground for rejection. Forget about that. Your NOA may have issued. You may have issued an NOA, or how a technical bid was considered. That was our whole case. However, it is submitted. Respondent authority are proceeding to allot the tender in respect of private respondent number 5. Mr. Das therefore submits interference of this court is necessary to restrict the process undertaken by respondent authorities for allotment of tender in respect of respondent number 5, who is not clearly qualified in terms of the eligibility criteria provided. It is also submitted by so-and-so by the senior counsel. Steps on so-and-so, this order, not to proceed to allot the work order in respect of the NIT for hire and scrapping winches for period of 5 years. Now what has happened? Now your lordship has put a query. My learned friend also raised an objection saying that 14th of January 2025, the NOA has been issued. NOA has been issued on 14th of January 2025. And the matter which was moved before this court was on 12th of February 2025. So NOA has been issued. But NOA has been issued to whom? Only to respondent number 5? Only to the respondent number 5 NOA has been issued? What is the submission that has been made and what has been recorded by the learned single judge? Saying basic foundation, what we have challenged is technical bid which was allowed. Now, so now once we came to know that NOA has been issued, I cannot get an order from the ONGC. Why the ONGC? ONGC otherwise in favoring the private respondent. Why they will give an order? I came to know when this particular was annexed with the application for vacating of that order. What I have done it, my lord. I have come with an application, additional affidavit, bringing notice of the NOA. And also, my lord, why to file a separate writ petition? I want to amend the writ petition by bringing only the prayer portion. Is this not, I am not permissible? I have seen, my lord, number of cases in be allowed by the court. Am I not permissible? Am I again resorted to go for a file a press writ petition? This is what I am giving an answer to your lordship regarding 14th of January 2025. Where is the bar? Am I not entitled to file an application for amendment and inserting the prayer of 14?
So you have already filed the amendment application.
Amendment application process today is going to file it.
And then the other one?
Additional affidavit bringing notice about 14th of January 2000.
That is already here.
And also their objection reply I have filed. Their application for vacating modification of the order, we have filed a reply to their application. Because your lordship will kindly look into it. I have clarified it. They said as a big voluminous a wastage of time. I will show it. No, they said that this is only mere delaying tactics. I'll show it before the court. What are the records? What is the bidder has submitted? That I want to show it. They said that equally a chance was given to you. They want now to say equally chance was given to me for clarification of those documents. So what is the wrong in giving a chance to the private respondent number? 5. What is the chance that has been given to me? That already was on record. That is why I want to bring it by showing it before the court. It is only you favored the respondent number 5. You want that particular lacuna, that particular gap should be filled up by respondent number. See kindly their application for modification. Variation. Kindly see that. Kindly see now. On the face of it, I will show it before this court, my lord. I have given a reply to this, my lord. See at page 54. They have issued to
Of the IA?
Of IA 666 of 2025.
Yes.
See this, my lord, 26/9/2024. My lord, see this, which is addressed to South Asia Council, which is respondent number, private respondent number 5. Page 54. 54. IFA 5.6. See the 26/9/2000, which was addressed to the private respondent. See now number 2, which is given to us. I will show it. Number 2. Please note that the submission of clarification, this is a question. Confirmation, deficient document should not be construed as qualification under the bid evaluation criteria of the tender. The supporting documents, wherever required to be submitted by you in response to deficient documents, confirmation sought by ONC should not contradict, my lord will kindly, should not contradict the details already given by you in the original bid. What is the original bid you have given? Operation and maintenance. We should not contradict, which you submit later on. It is only a clarification, deficient of the original date. Original is operation maintenance. That is why, my lord, I am reading this. Also note, document to be submitted by the bidder can be accepted subject to the condition that the basic structure of the bid and the vital techno-commercial BEC parameter on the basis of which bid has been originally submitted should not change. Now, what it was given to them, please see page 55. Page 55. What was given to the private respondent? See, my lord, now, kindly submit clarification, confirmation, deficient document. 1. Bidders may be given one opportunity to submit document as per BEC clause 2.1 to establish their eligibility. Where is the question? Your establishment of the eligibility criteria doesn't arise at all.
Okay.
What Dayaram Shetty says, that judgment, my lord. There were certain tenderers, if this is allowed to so and so, why others also should get the opportunity? This is what I am showing it, my lord. That is why I am given a reply. Kindly see. How can you do it, my lord? I very well understood deficient, and they said clarification, deficient isn't given to me. I'll show it what is the clarification. It was already on record. I'll show it, my lord. Kindly see page 55. Once again, my lord will kindly read this. Bidders may be given one opportunity to submit documents as per BAC clause 2.1 to establish the eligibility experience. To establish your eligibility experience doesn't mean deficient. He did not have the eligibility. Is apparent on the face of record. Your lordship has looked into it. The certificate pertains to the ONC which is given in respect of operation maintenance, which has nothing to do with capping of higher wages. Then Why you are, and your lordship has seen after the closing date on 1/8/2024, on 8/10/2024, you have given two annexures. That annexure is now because of the opportunity was given to you. This is a foundation, my lord. If that is considered by this court, now your lordship forget about the NOA, my lord. That is why I thought that your lordship will call it and your lordship will fix a date. But as my learned friend was insisting much on that, it should be vacated, it should be modified. What is the ground? Okay. Now, my lord, I will show. They said an opportunity was given to us. What is that opportunity was given? Is that we are submitting a new document? We did not. You have asked. Kindly see that photo. No, you have to. Now, please turn to page 125. My read petition.
You read petition.
My read petition. See 125. Eligible.
Yes.
At page 125. This is on 26/9/2024. Lordship got it?
Yes.
Same, which was given to the private respondent. Number 2 also is same. Please note that submission so and so should not be construed as qualification. BWN criteria of the tender. The supporting document required to be submitted. Same, which I read. Now kindly turn to page 127. See 127, my lord. Lordship got it? 127? See 127.
Yes.
What they were. Kindly submit clarification, confirmation, deficient document. Bidders need to submit a certificate duly signed from statutory auditor practicing CA confirming A, turnover figures of FY 201, this is 221, 22 and 222, 23, and whether network is positive or not negative. Now, if your lordship looks into it, in the writ petition, the lordship will find these documents were already there. Please see 105. 120 kindly be looked into 120 of the writ petition. Lordship got 120?
Yes.
And Lordship has read that page 26/9/2025, which I have read just now.
Yes.
And what clarification they wanted that for in respect of the present petition, kindly see this is what was there on record. Certificate of annual turnover, which they required. This is submitted, kindly see 27/10, 24/7/2024. Lordship has got it. And sternly, please turn to 121. As per records produced and expense given to us, certify herewith, son of so and so, a positive net worth for financial year ended on so and so. These are to financial year. These are part of this writ petition. Paragraph, my lord will kindly see at 16, page 16. See page 16, my lord. Page 16, paragraph 8.
Yes.
That the petitioner has considerable experience providing charter hire services of tapping winds and accordingly have the requisite work experience well as financial capability as per the terms and conditions of NIT dated 6/6/2024, submitted his bid on 24/7/2024, wide letter dated 27/2024, and thereafter resubmitted his bid again on 31/7/2024. Now, Annexus 7, copy of the relevant part of the bid submitted by so and so, letter dated 20 is Annex 7 and marked as Annexus 7. Which I have shown, my lord, that is Annexus 7. Now, so that is why we wanted to bring entire records, what we submitted before the court. My lord will kindly see what they projected in vacating of the order. They said that no, you cannot appropriate and reappropriate. Why you are taking the about respondent 5? You also given an equal chance. What is the chance you have given? Let's see it, my lord. At page See paragraph 14 of their IA. See paragraph 14.
Yes.
See paragraph. That the applicant said writ petition had taken the benefit of invocation of same clause 24.2.1, under which he was asked to give clarification, and while giving such clarification, he has submitted additional documents. If the content of the writ petition is to be accepted, then his bid was also techno-commercial deficient, for which he was asked to submit clarification deficient document. Thus the writ petition, having taken the benefit of the same clause, it is not open to him to question a similar benefit extended to another tenderer. They are not saying about anything, saying about respondent number 5. Tenderer. In other words, writ petition hit by doctrine of approbation and reapprobation, hence the writ petition not maintainable, and interim order is liable to be vacated. And what is those documents? Kindly see at page 33, 34, and 35. Original kindly see at 33, 32 kindly. So I will show it, my lord, because they will catch hold of us that you have not shown page 32. That's why I want to show it. What is page 33 and 34? Kindly look into it, my lord. 33 is a part of the earlier writ petition of my writ petition, which I have shown, and 34. Right, my lord? 34. See what clarification they have sought and what is 32. See what is 32. See what clarification they have sought. Kindly see this IA. See in the IA, kindly clarification of my writ petition. Writ petition, my lord. I don't know what clarification. 125, kindly look into it, my lord. See 125 and I will show this document. See 125 of the writ petition. See 125 which I have read, and kindly turn to page 127.
No, we are going from one writ petition to IA.
Because it has to be connected, my lord. I'm sorry to say. It has to be a connection with that.
So let us do one thing.
Yes.
Let us have the application filed by you for the amendment.
Yes.
We'll have it tomorrow. We'll
I have no
consider the
problem.
matter tomorrow.
Just one thing. My learned friend has
Tomorrow will be a big difficult.
Day after
made
tomorrow.
submissions, elaborate submissions on one of the merits of the case. I am just on two things.
No. See, Chaudhary, what I am proposing is let me see the amendment. Let me see the amendment. Then we'll.
Your Lordship, certainly, and in fact, my lord, perhaps we have not been served with a copy. Perhaps we may not even object to the amendment. What I am on is, how was the interim order obtained?
That's
I will
right.
just place two things, my lord. Your Lordship will first come to the entire NIT has been placed. One of the most important things, if your Lordship will kindly come to page 79. Page 79 of the writ petition.
This I've gone through.
No, my lord. I'm pointing out something else. Page 79 at the bottom, your Lordship will find clause 33, notification of award. If your Lordship kindly turns the page. 33.2. Notification of award will constitute the formation of the contract. 33.2. Now your Lordship will kindly come to the writ petition. The statement that was made in the writ petition. Page 31. What is the statement made in the writ petition regarding the notification of award? Page 31. Towards the middle, your Lordship will find the sentence starting now pursuant, as my Lord got. Line about 8 from top, sentence starting now. Now, pursuant to the opening of the financial bid in respect of the NIT dated 6/6/24, it has come to the knowledge of the petitioner that notice of award, it is not a notification of award. How they have misled. The word used is notice, and then your Lordship will continue, my lord, has been issued to the respondent number 5 on 14/1/25, but no work order or contract has been signed. So therefore, they do not place that clause 33.2. Now, what is the submission made before this learned single judge?
See, 33.3.
Yes, ma'am. Upon the successful bidders furnishing performance security pursuant to clause 36, the contract shall be signed between the parties as per clause 34. Yes, first stage is the one.
Plus the mobilization period.
mobilization, the logic is this, my lord. Why the notification of award, which is the work order, is issued, is that so that they get the 75 days for mobilizing, and so that that process can be expedited and the contract can be signed.
And the extension period up to May,
That is for the existing contractor.
that's why.
Total of, there are a total of 24 plus 14, 38 units. So this is in respect to only 10. I am not on,
But what you are saying is, so far as the respondent 5 is concerned,
my lord,
he has been given 10 units.
10 units, because he has bid for 10 units.
10 units.
And
The petitioner is aggrieved. with
he has
that
bid for only one.
Maybe,
Yeah,
maybe.
my lord.
But then, according to the petitioner, that you've gone beyond the.
No, those are the, those are on merit.
Those we'll consider later on.
My lord, today we are on simple thing. Firstly, whether on the date of the interim order, was the work order issued or not? Normally what your lordships do, when the work order is issued, your lordships examine the matter, making it subject to the outcome. Had this been placed, firstly, that statement, no work order has been passed, that statement is made at paragraph 31, and now your lordship will kindly see the submission made before the learned single judge. The out and out false statement made, page 31. Page 31. This is the submission, and till date, if it is an incorrect recording, they should have, it is part of judicial record today. They should have filed an application for correction saying that I have not made this submission. This is a submission, my lord. Line about 10 from top, sentence starting, however. However, it is submitted that the respondent authorities are proceeding to allot the tender in respect of the private respondent number 5.
Page 31.
Page 31, 30.
30.
30. Line about 8 or 9 from top, towards the right hand side, your lordship will find a sentence starting, however.
In the IA?
In the IA, page 30 of the IA.
Okay, 1 minute.
This is the interim order.
1 minute. Page 13.
With all sense of responsibility, I am making this submission, my lord.
1 minute.
Page 30. The statement on oath made in the writ petition is that no work order has been issued. And this is the submission before the learned single judge. Ex parte submission. Sentence starting, however.
Okay.
However, it is submitted that the respondent authorities are proceeding to allot the tender in respect of the private respondent number 5. Mr. So-and-so therefore submits that interference of this court is necessary to restrict the process undertaken by the respondent authorities for allotment of the tender. That allotment was already made on 14th of January. And based on this submission, what is the order passed, my lord, at paragraph 8? Till the next date fixed, the ONGC authorities shall not proceed to allot the work order. It is an infractious order, my lord. Work order was already issued on 14th of January. It is based on that statement on oath was perhaps not even shown to this honorable court, but the submission made is a contrary submission, that work has not been allotted. Based on that, on an ex parte statement, this interim order was passed. So therefore, in my respectful submission, my lord, when such conduct is resorted to, Supreme Court has time and again said that not only your lordship will impose cost, your lordship will hold them up in contempt. A false statement on oath, followed by a submission made before the learned single judge, based on which the work order has been issued.
Chowdhury, that will consider with.
So,
in the amendment petition.
at least, my lord, so far as the other, let these 10, I am leaving.
That I'll clarify tomorrow. All the others, heavens will not fall if you don't pass an order today. So we'll take up tomorrow. Miss Das, are you free tomorrow?
The whole problem is, my lord, entire work has been halted.
That part I am.
Tomorrow, if your lordship takes up in the morning part,
First
off.
That's the first item.
Say first item, then it will be easy.
Well,
Sir, Mr. Dida, the senior counsel. Assistant Barrister R. Sharma or Fukan Sharma? R. Sharma. Submits that they filed an application for mention of the amendment petition. So that they are filing an application.
Yes.
You are filing an application within the person. So accordingly, list this matter again on tomorrow what 18th, along with the set application for amendment as first item.
Interim order may be extended.
Okay, interim order passed.
Yes, I'm deeply obliged, man.
Till tomorrow.
Does see this interim order? This interim order, it is covering both Assam and Ahmedabad.
Your lordship will clarify it. We are not Ahmedabad. I made it very clear to your lordship.
Even in Assam, we are confined only to.
Only the respondent number 5. Yes,
That's only 10.
correct, right.
Your lordship may clarify that.
That's enough. There is no
Yeah,
problem,
that-
man.
that
Absolutely no problem.
We'll clarify tomorrow after seeing the.
Yes. I'm deeply obliged.
Admission.
Yes.
Lordship, till date, we have received only 1 lakh, and now the remaining amount is 6,07,966. They have yet to pay us.
Is it 6 or 7?
It was 7 earlier, but now they have paid.
Yeah.
Lordship, another 1 lakh has been paid. Lordship.
When?
On, as per my information on 12.
You are paying 111. What is this? When are we paying the full amount?
There's some problem. The problem is that we're not having fund, Lordship.
Okay, when can you pay another 2 lakhs?
2 months.
Not 2 months.
Or Lordship may dispose of the matter by saying that within 6 months the remaining amount may be paid.
Lordship, 6 months is a bit too late, and if it is disposed, then again they would be slowing their payment. So it is better it's kept in the court, and they.
I'll give you 3 weeks to pay 2 lakhs again. Okay.
I will inform them, Lordship.
Mr.
C. Sharma.
C. Sharma and Standing Council ASTC.
Yes.
Submits that apart from the 1 lakh that was paid to the petitioner on 15/2/2025, another 1 lakh was paid on 12/3/2025.
12/3/25.
12/3/2025. Stop. Mr.
And go with.
N. Gogoi. Para, huh? No. So stop. Para. Considering that, when was the due? When was the due date? When was the last time the running bill was paid?
Last Lordship we have paid on 12/3.
Considering that the outstanding due to the petitioner has been for a considerable period of time, comma, the authorities in the ASTC is directed to pay another 2 lakhs to the petitioner within a period of 3 weeks from today. Stop. List the matter again on, give a date immediate after 3 weeks.
11th.
11th of April.
No.
11th April.
11th April. Oblige.
Make sure you pay the 2 lakhs.
12.
Lordship. I'm appearing on behalf of Mr. N. Data for respondent number 1 and 2. My lord, we have obtained the instruction as to the current status of the connection. So we'd like to place that on record by filing a.
But if I may furnish a copy of an IA which has been disposed, just for your lordship's. Where is it? Dara. Oh. It might be disposed of. Your lordship will kindly come to page 18. Page 18.
What is this IA about?
This IA has been disposed of, but there are certain facts in this IA which my friend has, the information that my friend has gathered, it's already there, page 18. Now, what happens, your lordship, in this matter is that the petitioners are the owners of second and third floor of a building. My friend who appears for the respondent number 3 and 4, they stay at the ground floor. Now, there is a transformer which was installed, a 100 kVA transformer that routes electricity to all the floors through separate submeters. Those submeter connections, the number has not been disclosed to us. Now, as a consequence, what has happened is that we have to pay a certain tariff to my senior friend's client and thereafter recharge. Now, the only relief that I want here, your lordship, is that my submeter consumer numbers be indicated to me so that I can recharge my own electricity. That is the only extent of my prayer, because the APDCL, your lordship, at C, at that correspondence, they have made it clear that a separate electricity connection cannot be provided to me. I have no dispute to that, since there are already reasons.
So you just want to know
my consumer number that I can recharge my own electricity.
Separate this submeter numbers.
So my friend has gathered information about the consumer number. That consumer number is already known to us. Your lordship, let's see page 18. Page 18. Your lordship will kindly see page 18.
But consumer numbers.
Number 3, point number 3. Meter number and consumer number is already indicated to us. The issue is that it is routed through separate submeters. For that, I have to approach respondent number 3 every month. And the problem here is that I have tenants living there. It's a commercial establishment and they need sufficient flow of electricity through and throughout. Now, I am prejudiced to the extent of 10,000 every month.
We will provide the separate submeter numbers to them.
If they can, alternatively, my friend can also do that. If he can
When
do
can
that.
you do it?
2 weeks time maybe granted. We will place it on record that instruction that we will see.
Yes.
My senior friend can also do.
What the IA has been filed.
No, that is not in. That is not
Even I don't know what
no,
is
that
this
is
IA
not,
about.
no, this IA has been disposed of because we wanted the connection not to be disturbed. That is, this IA has been disposed of. This information.
But I am in the party of the IA or
No,
I am not known.
No, this is just to indicate to the lordship that is information that my friend has gathered today is already known to us. This is not to press the IA.
Is this the information that you have?
This is the information.
What is the
Same information the lordship will see. We already have the information. This is not in dispute. I'm not pressing the IA. This IA has been disposed of. Electricity connection.
So now you already know your consumer number.
I know the consumer number, but through the consumer number, there are separate submeters that are routed through each of the floors. I do not have my submeter number. Floor number 2 and floor number 3. Your lordship says.
Submeter numbers are mentioned.
Submeter number. Consumer number. So I already have that information. Your lordship, that's the reason I indicated that on page 18.
The submeter number is also here.
No. This is not the this, we require a separate consumer number. This submeter is the number which is the meter number. There's a consumer number by which the recharge
Consumer number is also here.
The consumer number, that consumer number is already indicated to us. That consumer number is the big consumer number through which all the floors in that building, they're routed through separate submeters. Your lordship will see 060012. That is already indicated to us. We already know that. Now what happens is the electricity from the APDCL plant is routed to the transformer, and thereafter there are 3 separate lines that go to 3 separate floors.
Okay.
Respondent number 3 is the one who had installed that transformer, and he is aware of the submeter consumer numbers of all the floors. I am not aware of it. Now, what happens here, lordship, is that I have to every month, I have to approach my respondent number 3, who happens to be my elder brother, and pay an amount which is beyond the recharge amount. Now, I'm not assailing anything against my respondent number 3. The only relief that I want is that if he can provide me the separate submeter consumer number for me to recharge my own electricity, that is the extent of my prayer.
Lordship, there are long pending dispute between that petitioner and the.
That is not here. That is not here.
Which I am representing. That is transformer as per my instruction has been installed at the cost of my client, the transformer 3 and 4. And he also claiming that the same electricity from my customer, which is my investment. That disputed question fact, my lord.
Then at least you can provide if he's not interested to provide.
That is the issue.
You provide, we'll take up on Monday.
Your
you
lordship,
provide it.
close the petition. That is
No,
the
no.
only extent,
Let
because
him-
they've said that they cannot provide me separate connection.
Let him provide the number.
Only that, nothing
On
else.
the Monday, we'll close the matter.
Yes. This IA was just for your lordship's perusal, because we already had that information. That was just to.
Part M. Shamal and the council for the petition. Mr.
S. Panikya on behalf of Mr. Endek.
S.
Panikya on behalf of Mr. Endek.
Learned Council appearing on behalf of Endeka, Learned Standing Council APTCL shall provide the submeter number.
Yes, submeter consumer numbers.
Submeter consumer number in respect of the petitioners.
To recharge my electricity, that's all. Yes.
Before this court. On 24th March. Okay. Release the matter on 24th March. You just provide the submeter consumer number.
The lordship may, if I may have the copy of the IA.
You can
Yes,
take it.
yes. I'm grateful, your lordship.
17 and 18.
May I please, your lordship? In this matter, lordship, I need some accommodation, lordship. Otherwise, lordship, readings are already complete, lordship. Lordship may kindly take up this matter for admission hearing on 8th of April, lordship, subject to convenient. I have already. 8th of April, lordship.
Yeah. Okay, on request made by Mr.
NK Sharma.
NK Sharma, Learned MP.
NK.
NK Sharma, Learned Council for the petition. Release the matter on 8th April.
19.
May I please? This is regarding non-payment of higher assessors bill of the vehicle mail. The police authority may not requisition the vehicle of the petitioner mail.
Affidavit has come. Not yet.
In this case, Lordship, I have received instructions, Lordship.
Is it an admitted amount?
Lordship, admitted some proposal is sent to the Lordship, the authority in 2023 itself, Lordship. Lordship may dispose on the basis of instruction, Lordship, regarding admissible amount, Lordship, you have no objection. After verification, Lordship.
What is the admitted amount?
Here is not reflected, otherwise, Lordship, proposal is sent for in respect of one vehicle, 1,27,020, Lordship, another is 1 lakh, Lordship, may kindly peruse.
My claim amount is 8,87,483, madam.
You claim?
Yes, madam. For the period, madam, 1/2019 to 36/2022, madam.
Next page, chart is there, Lordship, regarding sending the proposal.
Who took your vehicle? Commissioner of Police.
Yes, madam.
Hired a vehicle.
Yes, madam.
For?
It is with effect from 1/2019 to 36/2022, madam. And find this in synopsis also, madam. The period, madam.
1 minute. No, it was hired for what purpose?
Lawyer under purpose, madam.
Okay, hurt Mr. S. Botakul.
Lordship, just indicate, Lordship, if they are not paid, Lordship, yes, because it's 2023 instruction, Lordship.
No, I'll just say to verify and
Yes,
pay the admitted
Oh,
amount.
obviously, madam.
Mr. S. Botakul and the counsel for the petitioner. Also heard Mr. K. Gogol and the additional senior government advocate appearing on behalf of all the respondents. Stop. The petitioner is the owner of
Maruti van, madam.
Maruti van bearing registration number AS-01-DX-5186. And his vehicle was, it was requisitioned,
Yes, madam.
was requisitioned by the office of the
Commissioner of Police, madam.
Commissioner of Police, Kamrup,
Yes, madam. Guwahati, madam.
Commissioner of Police,
Guwahati city, madam.
Guwahati City.
Yes.
For law and order purpose for the period 1 to 2019 to 36 2022. Stop. Thereafter, the petitioner submitted the bill before the Commissioner of Police, Guwahati, oblique respond number 3 for making payment for a total amount of rupees 8,87,483. Correct?
Yes, madam.
483. Stop. However, despite submitting his bill, when did you submit your bill?
No, I have submitted the bills, madam. Madam, fine, madam, from page 12 onwards, madam.
Thereafter submitted his bill. No need for date set. So, however, till date, the total outstanding due of rupees 8,87,483 is yet to be paid to the petitioner. And accordingly, stop being aggrieved. Petitioner is before this court by way of present petition. Stop. Para. Mr. K. Gogoi, and additional senior government advocate. On the basis of instructions submitted by the Deputy Commissioner of Police within bracket crime, Guwahati, dated 3
So extreme right, probably that is there of them 20.
It's, I think it's 310, I think. 310, 2023. Submits that the bills received from the petitioner have been forwarded to the sanctioning authority after declaration of the declared amount of after deduction of the
20
declared amount
20% deduction.
of 20% for according sanction. Stop. After that, you have no idea what has to happen. Stop. Para. Considering the submission made by the learned additional senior government advocate Assam.
Madam, may otherwise indicate that proposal part, madam, may one paragraph may indicate that proposal
Where?
part is there also. Proposal number is there also, bill proposal number is there.
Stop. Okay.
That part, madam, may indicate.
Then I cancel that line. Stop.
Details of bill forwarded for lordship sanctioning authority, that part is there also.
Para. This court has considered the instructions submitted by the Deputy Commissioner of Police Crime within bracket crime, Guwahati, wherein the details forwarded to the sanction authority are given and the same reads as under. You copy it down. A to A. Stop. Para. Considering the instructions submitted to the learned additional senior government advocate, comma, dispute petition is accordingly disposed of. Directing the response number 3 to
indicate respondents authority, otherwise yes,
considering the respondents to have a verification of the bill submitted by the petitioner with regard to the hiring of his Maruti van by the office of the Commissioner of Police, Guwahati City. Stop. draft on verification. If the amount claimed by the petitioner is admitted, comma, the same shall be paid to the petitioner. Within a period of?
Okay, 4 months may be given, but March ending is there, so 4 months. Within a period of 4 months.
Within a period of 4 months.
Lot.
From the date of receipt of a copy of the order of dispute. With the officer of observation.
Madam, may kept it a part of the record.
Huh? The instructions dated 3/10/2023 is placed on record.
Lot.
In other one also similar lordship that I. Here claim is lordship, claim amount is only defined lordship.
4,30,000.
4,30,630 lordship.
Same, just say.
The period is made to 1/1/2017 to
Is
3.
the owner of a vehicle, Maruti van bearing registration number AS 01 BR 8613, and then hiring for a period for the period 1/1/2017 to 3/3/2019. Okay. And the amount due is 4,30,631. Correct?
Lots, yes, but here also chart is there, so my lord may get chart.
After that, you say the same thing in the chart. 8A. Okay. In the same order, the instruction dated, the instructions will be dated 29/9/2023. Okay, the instruction dated 29/9/2023 is placed on record. Okay.
Lots.
21.
This matter, they were supposed to file affidavit. Respondent, Lordship may kindly see the order dated 17/11/2023. Petitioners are registered pharmacists. Their registrations were cancelled, Lordship.
Yeah, who's the respondent?
Health is there, Lordship.
Health Department, Gogoi. Upamanyu.
21. After some time. 23.
Lordship, in this matter, in the last occasion, they have filed an affidavit. So, Lordship, we would like to file a reply to that.
What affidavit did you file?
File on 13/3, my lord.
It is not on record. 13/3.
13/3, Lordship. They have filed.
Mr. Bora. Learned Standing Council,
GMC.
GMC submits that they have filed an affidavit. They filed a counter affidavit on 13/3.
13/3, Lordship.
2025. Stop. Register to verify and place the same on record if found in order. Stop. Mr.
H. Bitala, Lordship.
H. Bitala, and counsel for the petitioner, prays for
3 weeks time, Lordship. We'll
3
file
weeks time to file reply to the counter filed by the GMC. Praise a lot, just after 3 weeks.
that. Obliged, Lordship.
24.
Please, Lord.
Who appears?
Hoka Municipal Corporation Councils.
And 4.
Yes, Dr. Nimis.
Doctor, who is this? Yes, doctor. It's not the one who's sitting behind you, isn't it? It's doctor, not that, not the doctor.
Not doctor, he's not doctor.
Huh?
He's not.
He's not the one.
No.
Respondent also supposed to file affidavit by last week. They
Who's this S doctor? No. No. 3 and 4 is something else.
not
The Boca Municipal Board.
Not yet, not yet pursued. Not yet engage any. Huh?
No.
Regarding lordship, the allotment of vita lordship, the municipal body is the
Yeah.
authority lordship. We have no rule lordship, so their presence is required.
I don't know who's is
As Dr. My lord appeared in the last.
on 24/5/2024. One
Yes,
is Datta appeared. That's why
Yes.
we directed his name to be reflected. I don't know. Can you just check up who is this is Datta and then we'll take up after some time.
Well.
25. This pertains to outstanding liabilities from the Water Resource Department, my lord, Karimganj district, my lord. By filing affidavit, my lord, they have admitted, my lord.
Where is the affidavit?
My lord, page 59 of the affidavit in opposition, my lord. Paragraph 6.
Paragraph 6.
Yes, my lord. 59 page number.
8,16,000.
No, my lord, 31,62,000 and 84 rupees.
Lordship, yes, I think that. Lordship, scheme number 6 on page number 59, that's not related to water resource department. It's related to SDRF, Lordship. For
Scheme 6.
Yes, Lordship. For the deputy commissioner with Peter.
My lord, deputy commissioner has also been implemented, my lord. And
Who's the
admin,
deputy commissioner? Gogoi.
Our name is not reflected here.
Your name is not there. Yes, correct.
So Lordship may reflect our name, I will verify.
my lord, in the affidavit in opposition, there is no mention of that kind of statement.
No, that's fine.
And,
But then at
least-
least she's clarifying. Let Gogoi get some clarification and come.
Lordship, put that any other day by reflecting our name, Lordship. in the
By
meantime,
next week, we can dispose it of. It's a financial year ending. Heard SR Rabal and the council for the petition. Registry is directed to reflect the name of your name, Gogoi?
No, Lordship, Zia Assam.
The government advocate Assam in the first list. And list the matter again on 26th.
Lordship.
Okay. March.
26. And also, my lord, the parts of the bill has been not been released. No. Out of the total bills, some are released and
PWD. Gogoi.
they are supposed to take instruction as per.
Item 26. But that is awaited. Lordship will give me some further time, 10 days time.
You heard, Mr.
SK
Devril on the council. for the petition. On request made by B. Gogoi and a standing council PWT. How much time?
10 days, madam. 10 days time.
2 weeks time is allowed to enable him to receive instructions. List.
Yes, my lord, let it be on 7th of Monday.
7th April. 7th April.
Apply, sir. 27.
Same melody instruction is awaited, madam. Same day, madam, 7.
My lord, it can be disposed of. The amount is undisputed, my lord. Just one annexure will clarify at page 49, my lord.
Let
They
me
have-
have the inspection.
They have said, my lord, that due to paucity of fund, the amount could not be released, my lord. Page 49, last line, my lord. This is the instruction, my lord. Till date, I have not received, my lord.
No, madam, let me have the instruction. Madam, let it be on 7. I will come out with it.
Come on, 7, come on.
7th of April.
No, my lord, the financial year will
No,
elapse.
so now it cannot be released. If they will have
No,
to
if
go
they want, my lord, within a 2-3 days,
No,
they
no,
can
no.
do this, my lord.
already the last date for submission of proposal is over. Sealing proposal, my lord, that online portal is closed. I am from the finance department, I know.
Anyway, you manage,
Malik.
you somehow manage to pay him 19 lakhs.
Only small amount, my lord.
But yeah, Brian, learned counsel for the petition on request made by Mr. B. Gugoi, learned standing counsel, PWD. List on. Seven.
Oblige, my lord.
28 to 36.
And on the last occasion, inspection was sought
48 to 36, Lordship, we need some time, Lordship. In this case, the main part, Lordship, we have already paid. The additional work we have done, Lordship, without the administrative approval, that was done. We have filed affidavit in that regard also, Lordship. Now matter is pending for the administrative approval. So Lordship may fix the matter after 2 weeks. In the meantime, we come up with the instruction, Lordship, whether that part, extension part is administrative approval is granted or not.
Okay, heard, Mr.
M. Sharma.
M. Sharma, learned counsel for the petition. On request made by K. Gugoi, learned additional senior government. List the matter.
After 2 weeks, Lordship, in the meantime, we
After 2 weeks.
Date may be fixed, my lord.
Okay, list the matter. Okay, 2 weeks time is allowed to enable him to receive instructions. List on 2 weeks is what? Okay. 2nd April.
Lordship.
38, 39, 40.
Whereas these cases have become impact of Lordship. The petitioner had challenged the tender process, Lordship. The process is already over. And nothing survives in this petition. The whole process of settling the tender is over, Lordship, and in fact, Lordship, the 2 tenders were, one already work has been completed by the elected bidder, Lordship. The other one also 65% work has been completed, Lordship.
Okay, okay, none appears for the petition. Mr. Yanobadia, the standing counsel.
Irrigation.
Irrigation, appears for the irrigation. List after 2 weeks. Maybe he's not interested.
Maybe. Lords, oblige.
44.
My lord, here is the case relating to the non-payment of higher charge, my lord. And state has the filed the affidavit, my lord. Affidavit says, my lord.
Higher charge by whom?
Higher charge by the Home Department, Police Authority.
Commissioner of Police.
Yes, my lord.
My lord may dispose of the matter. Some amount has been forwarded and remaining some amount is under verification, my lord.
They admitted, my lord, they said, my lord, lordship, kindly have a look, page 136 of the affidavit, my lord. Verification আছে কৰিলো আৰু এক লগত pending কৰি থম এটা কেছৰ
Yes, you'll find some difficulty, I think, no? If you make a mistake, there will be a big problem.
Yes, my lord. Lordship has already disposed of, my lords.
No, fine, that's fine. If I.
My lord, lordship is.
Yes, my lord, it will be better, my lord.
Huh?
Putting these figures will be better, my lord.
No, that's why he may have some problem. Supposing if something goes wrong with the date in the vehicle number, then
My lord, lordship will dispose of in the light, my lord, 2015 to 2024, their requisition vehicle. I am claiming amount 2 lakh or 2 crore 3 lakhs 58,995 in the synopsis itself is there, man.
No, fine.
And they filed the affidavit, my lord, saying that, my lord.
Okay. Heard Mr. Jaya Bharwal and the counsel for the petition. Also heard Mr. G. Bakalia and the governor advocate for appearing on behalf of
for all respondents.
All the respondents. Stop. The petitioner is the registered owner of vehicles bearing number in the synopsis. In the synopsis, bearing number, bearing registration number. A to A, respectively, which was hired by the respondent number,
Respondents, my lord, lordship.
by the respondents on different dates in the year 2015 to 2024 for maintaining law and order situation. Stop. The petitioner draft submitted a bill amounting to rupees 2,03,58,955 on account of the hiring charges of the petitioner's vehicle before the respondent authorities. However, not a single penny has been paid.
No, madam.
However, till date, the petitioner is yet to receive any payment. Stop. Any payment, and accordingly, the present litigation. Para. The respondent number 6, Deputy Commissioner of Police, within bracket, Administration, Guwahati, has filed an affidavit. And in para 4 and 5, it is stated as under B to B, page 134. This will take long. B to B. That is from page 134 to 146. Huh? Stop. Para. Considering the amendments made in the paragraph 3 and 4, paragraph 4 and 5 of the affidavit in opposition filed by the respondent number 6, dispute petition is disposed of, directing the authorities to have a verification with regard to the claim of the petitioner for his outstanding bills amounting to rupees 2,03,58,955. Thereafter, on verification, if the claim of the petitioner is found to be admitted, the same shall be paid to the petitioner within a period of 4 months.
My lord, can it be 3 months, my lord, because
This is a-
we loan, my lord.
This is a big amount.
It will take lordship another 6 months, lordship. So lordship,
4
4
months.
months. Lord.
From the date of receipt of a certified true copy of this court order with the above observations and directions. Verification is necessary.
আরোটা আছে না
45.
It's similar, my lord.
May I please. This is non-payment of contractual liabilities, my lord.
I'm representing Tiwar North. We have filed the affidavit. Otherwise, the construction work was verified, my lord.
Huh?
It's been verified by the authority, my lord.
Where is that?
It's an
Where have you
admitted,
stated?
para 9, my lord, of the affidavit in opposition filed by the Tiwar North. The page 25 will, the relevant portion is there, my lord. Para 9, fifth line from the bottom line.
So practically that it's an admitted amount.
Yes.
How much is the amount?
It's 4 lakhs, my lord. 6 lakhs as first installment has been paid.
6 lakhs has already been paid, my lord, as the first installment. Now
4 lakhs is.
Where's your work order?
Work order is page 11, my lord.
No, this is not your work order. This is a sanction order.
This is the work order, my lord. Work as well as sanction, my lord. Because in Tiwa Autonomous Council, my lord, they have at the time of issuing the work order, my lord, they have issued a first installment, my lord. They have paid the first installment.
Along with the, my lord, work order, first installment is
After completion of the work, my lord,
remaining
amount.
after verification.
So first installment, that means you don't have to invest anything.
Yes, my lord.
So with the first installment, you do the
Yes,
work
ma'am.
and then you get the other work.
Yes, my lord.
It's interesting. Okay, heard Mr.
NJ Khatuni, my lord.
NJ Khatani, learned counsel for the petition. Also heard Mr. SK.
S. Niogi.
S. Niogi, learned standing counsel.
Tiwa Autonomous.
Tiwa Autonomous Council. Stop. Para. The petitioner. No. By an order dated 3/3/2018. Issued by the Principal Secretary, Tiwa Autonomous Council, Morigaon. At administrative approval was accorded for an amount of rupees 10 lakhs only. And sanction also was accorded for an amount of rupees 10 lakhs. Stop. 10 lakhs in favor of the petitioner for
Construction of Tiwa Samadhi
construction of Tiwa Samadhi within bracket Dikachang
at Bamfor.
Bamfor. At Bamfor. Stop. The petitioner accordingly completed the work and utilization certificate was issued.
Yes, my lord.
And utilization certificate
Then inspection report and completion
amounting
certificate.
to rupees 6 lakhs. No, utilization is not required.
Completion and inspection report is there, my lord. Page 15 and 16.
Cancel that part. The petitioner accordingly completed the work and a completion certificate was also issued by the APO within bracket technical Tiwa Autonomous Council, Morigaon was stop. That's all, completion certificate only.
Yes, my lord.
So how much you are supposed to get now?
But, bill is at page 14, my lord.
Page?
Page 14. This is the final bill I have submitted, my lord. Total amount to be released, my lord.
After petitioner submitted the final bill for an amount of rupees.
Total amount to be released, my lord, 3,60,000 after deducting the GST, my lord. 3,60,000.
For a total amount of rupees 3, 60, 000, huh? Stop.
After deducting the tax,
Deducting the.
After deduction of
tax.
taxes, stop. However, till date, the petitioner is yet to receive the set amount of rupees 3, the set amount till date, stop. But the principal secretary is who? The respondent number 2,
Yes, ma'am.
public principal secretary, Tiwa Autonomous Council has filed contra affidavit. And in paragraph
9.
9, it is stated that the claim of the petitioner has been verified and inspected by the APO within bracket technical, Tiwa Autonomous Council, Morigaon, Assam, and also by the executive engineer, TAC Morigaon. Stop. Morigaon, and as per the report, the petitioner has successfully completed the said work. Stop. But considering the averment made in the counter affidavit filed by the respondent number 2, common dispute petition is disposed of, directing the authorities to pay the amount, pay the outstanding amount to the petitioner. I'm not citing the amount because GST will have to be
Yes,
there.
yes, ma'am.
The outstanding amount to the petitioner within a period of
45 days minimum.
minimum 45 days, within a period of 2 months.
2 months. 2 months.
From the date of receipt of a copy of the order. With the above.
Obliged.
46.
This is also
Matter is similar to the item number 44.
only
Here-
figure and year will be changed, my lord.
And,
But that was taken by a different,
This,
you took it, no.
this. Lordship,
Lordship may quote our paragraph 5, my lord.
4, 5, 6.
5.
Heard Jai Barbuya,
Amount, my lord.
learned counsel for the petitioner. As well as Mr. G. Bakalia, learned governor advocate. Appearing on behalf of all the respondents, on behalf of all the respondents, stop. Para, the petitioner is the registered owner of vehicles bearing registration number in the synopsis A to A respectively, which were hired by the respondents on different dates in the year 2019 to 2024 for the purpose of maintaining the law and order situation. Stop. The petitioner thereafter submitted his bill for an amount of rupees 99,29,909 for payment by the respondents. However, till date, the said outstanding due to the petitioner is yet to be paid. Stop. But the Deputy Commissioner of Police within bracket administration Guwahati, public response number 6, has filed counter affidavit. Stop. In the stop. We're in at para 4 and 5. It is stated as under B to B, page 83. Hmm. 83 to 86. Stop. Para. Considering the averments made in para 4 and 5 of the affidavit in opposition filed by the respondent number 6. This petition is disposed of, directing the respondents to have a verification with regard to the outstanding dues claimed by the petition. And thereafter, if the outstanding dues claimed by the petitioner is admitted, the same shall be paid to the petitioner within a period of 4 months from the date of receipt of a copy of the orders. You just check up with what you call this. Bahadur.
Obliged, man.
47.
Make please your lord. My lord, the matter pertains to non-payment of contractual dues. This is under the SDRF scheme, my lord, where 4 projects were allotted to the petition. And accordingly,
In this case, also we need some time to obtain instruction. It's a SDRF scheme, lordship, so we have to obtain instruction whether that amount can be. So, lordship, after 2 weeks, lordship.
lordship will give me a date.
Mr. D. Chakravarti, then the constable. On request made by Mr. K. Gogoi, Learned additional senior government advocate. 2 weeks' time is allowed to enable him to receive instructions. Please join. Fourth appeal.
Obliged.
49.
My lord, in 49, my lord, my friend has an instruction where, my lord, the admitted amount which already is annexed, this seems, my lord, is under process. So your lordship will give them a time frame for payment, my lord. They,
49, lordship, we have
in
given
item 49.
instruction. A proposal department has received, lordship, from the district commissioner, lordship. It is
Otherwise,
under process, lordship.
my lord will see page 44 of my rate petition where, my lord, the amount has already been admitted by the executing department.
What is this work against?
This also, my lord, is under SDRF scheme. This also, my lord, pertains to one project. The work order, your lordship will find at page 35, and the completion certificate at page 35.
35.
Yes, my lord. And the completion certificate at page 37.
Okay.
And the completion?
Completion certificate, your lordship will find at page 37. And since the bills were not paid, my lord, we preferred a representation that your lordship will find at page 43, wherein we had asked for issuance of a liability certificate at page 43. And accordingly, we have been issued at, in fact, at page 42 is the representation. And at page 44, your lordship will see the liability certificate where the executing department has admitted the outstanding bill amount of 4,33,161, my lord. At page 44, my lord, your lordship will see the certificate.
Okay. Heard Mr. D. Chakravarti, learned counsel for the petition, as well as Mr. S. Datta, learned standing counsel.
Revenue Department.
Revenue Department for the respondents.
2 and 3. 3.
2 and 3. Gogoi, you also there? Water resources, who is happening? Then you say heard MS J. Gogoi, learned standing counsel, water resources for the respondents. 1,
1, 4, 6, and 7.
1, 4, 6, and 7. Mr. S. Datta, learned standing counsel.
2 and 3.
Revenue and disaster management for the respondents 2 and 3. And Mr. K. Gogoi, learned additional senior government advocate for the respondent number 5. Stop. Para. The petitioner was issued a work order for immediate measures for restoration of flood damages within bracket cut of Uttar Krishnapur to Tarapur dike, including at Pitukandi for flood damages of river Barak under SDRF for 2022-2023 for an amount of rupees 4,33,171 by order dated 13/5/2023.
I'm sorry, Lordship. That inspection we have received, that scheme of work is different, Lordship. That work is different.
Very clear. Case number 39. My lord, ठीक है तो
That, as per my instruction,
This is a different work.
Lordship, different work, that I have to take instruction. Just now,
This is a different work.
my lord.
Let him get chance.
My lord.
Okay, heard Mr. D. Chalavati, let me counsel. On request made by S. Datta, Learned Standing Council, Revenue and Disaster Management Department.
Can
How
this-
much time?
2 weeks. My lord, can this matter be also on 4th, my lord?
2 weeks time is allowed to enable him to receive instructions. List on 4th.
4th of April.
Observe. 50,
Give back the instruction.
May I please the Lordship? My lord, I'm seeking some more time, Lord, 2 weeks to receive the instruction.
Heard Mr.
P. Talukdar.
P. Talukdar, Learned Council for the petition. On request made by Mr.
I bought up.
I. Bhattakul, Learned Standing Council, PHE. 2 weeks time is allowed to enable him to receive instructions.
My on 4th management taken.
What communications are taken? 7th.
51,
May I please Lordship? In this case, my lord, a private respondent, my lord, at the time of submission of tender, my lord, has not submitted the NOC from the cooperative. As per clause 8 of.
Private respondent.
Yes.
Who's the private respondent?
Respondent, my lord. Private respondent Usman Ali.
Usman Ali.
Yes. As per clause 8 of the NIT, my lord, page 23.
Yes, Ali.
Last time also not appeared. No, whether?
Where is he? Respondent 5.
Respondent 5, last occasion also not appear.
Last occasion you were not there. None appears for the petitioner.
Last occasion, none appears.
10/2/2025, none appears for the petitioner. Then, where's R5? Where the name is reflected?
Reflected.
No. This item 51, no?
51.
50.
Item 50.
51.
50. His name is not reflected.
Yes, Ahmed.
Yes, not reflected.
But he's the caveat terminal.
He's the caveator, but he wouldn't know, no? His name is not reflected. Let his name be reflected.
I have filed affidavit, Lordship.
Okay.
Shorted maybe.
Okay. Heard Mr.
A. Ahmed.
A. Mohammed, Learned Counsel for the petitioner. The Transport Department, which is represented by the Learned Standing Council MS MD Bora, has filed affidavit. None appears for the respondent number 5. Stop. Registry is directed to reflect the name of Mr. S. Ali. S. Ali, isn't it?
S. Ahmed.
No.
As per,
Yes, Ali is here.
yes, Ali.
Uh,
Ranal.
Learn- No, Mr. S. Ali has the London Council appearing for the respond number 5 with the first list and list the matter again on next week you want.
Lordship, in last week of March, I will be available, Lordship, and first, after 2nd of April, Lordship, any date.
Okay. Fourth.
Lordship.
Fourth.
Deeply obliged.
52.
Ma'am, please, your Lordship. Matter pertains to non-payment of. We required some time, Lordship. We have not received instruction, Lordship. Well, at least 3 weeks time may be granted, Lordship.
But Mr.
PP Bottakul.
BP Bartakul and the council for the petition on request made by Mr. K. Gogol and the additional senior government. 3 weeks time is allowed to enable him to receive instructions.
Date may be fixed, madam.
List on 9th April.
53.
No affidavit has been filed with the respondent. The last week is on, there was an observation, the interim would be considered to the Lord. Some protection is already there. No.
There's no protection.
You're only, in that case, no coercive action, or at least children like that. My instruction is awaited, I have communicated.
Heard, Mr.
P. Sharma.
Learned counsel for the petition. Mr. B. Gogol and standing counsel PWD.
PWD.
Praise for how much time?
2 weeks, madam.
2 weeks time to enable him to receive instructions. List after 2 weeks till the next interim.
Well, Lordship will give a date, madam, regarding a contract.
Okay, list the matter. When do you want 2 weeks?
Again, madam, on 7th or 3rd, madam, 3rd of April.
3rd April, till the next reasonable date. No coercive steps be taken against the priest.
21.
I think, Mr. DOB, he's present. I think otherwise they covered one matter. Cancellation of registration of pharmacists. In fact, Lordship, while sitting in the division bench, has passed an order directing them to go for appeal, statutory appeal, under section 36. And we are directed to provide them a minutes of the meeting by which they have been, registration has been cancelled.
Where is that order?
Placing an order. In fact, Lordship's order is reflected in this case. It has been passed by coordinator. In para 3, it has been.
Para?
The last para of that order. Otherwise, the cancellation is page 122. 122. Onwards. Till 128. Several cases have been disposed of on this term. Following your Lordship's order in the division bench. Same thing, all have been allowed to go for appeal.
Because there is a
Yes.
statutory provision.
I'll have to produce the order, Lordship, and I'm led by Senior Counsel, Lordship, Mr. BD Das.
Okay.
Then,
Then Wednesday, when they have to do.
Lordship, Senior Counsel, he's not present in station, Lordship. Lordship may take up the matter on 24th or 25th, Lordship. Any day after 21st, Lordship.
Okay, on request made on behalf of Mr. BD Das and the senior counsel for the petition. When do you want?
Lordship, 24th. 24th.
Monday?
Monday.
24.
Well, I verified the record, my lord. There is no wakalatnama of S. Datto, my lord. And S. Datto of PNRD, he said he.
No, no.
Any other day, otherwise,
My lord,
I have no rule. We have no rule. As data distribution is the Doboka municipal board. As on that, Lucy, whether that.
No, but then in this one,
no.
24/5/2024.
Yes, my lord,
have you seen?
24/5 he appeared. Thereafter he had not appeared. 25 he only appeared for raising objection, my lord, for interim order. No note about the Wakalatnama or appearance. my lord.
So what do we do now?
One chance, maybe, my lord, next week maybe fix, my lord.
Okay, hurt message, counsel for the
Dusty lawyer
petition.
paise. They receive.
As well as Mr. K. Gogol and an additional senior governor advocate for the respondents, 1 and 2.
I'm for 1 and 2, Lordship.
1 and 2. None appears for the respondents, 3 and 4. List the matter again on after 2 weeks.
My lord, next week, my lord.
The 2 weeks.
25.
List the matter again on 1st April. Interim order pass ready to continue till the next September.
54. Order. $54.
None appears for the petition. List after 2 weeks.
I'm sorry, my lord. I'm sorry, on 24, my lord. They are fixed on 3rd, my lord, instead of 1. 3rd April. All right.
55.
55, my lord. This is the contempt for non-compliance of the order dated 24/11/2021. Page number 12. Well, here I am appearing for the newly implemented incumbent. File my affidavit, madam. Newly implemented incumbent. I will.
Who's the newly implemented incumbent?
Number 2, Akashdeep.
Akashdeep. BTC.
BTC.
Okay. Heard Mr.
A. Boro, my lord.
A. Boro, learned counsel for the petitioner, Mr. S. Bora, learned counsel, enters appearance on behalf of the respondent number 2. And prays for
3 weeks time, my lord.
3 weeks time to enable him to receive instructions and file after with praise allowed. List after 3 weeks.
56.
Here I have filed my affidavit, my lord.
Please, Lordship. File the affidavit, Lordship, and also file reply also, Lordship.
It will be filed on 9/3/25.
Yeah, it is there. 1 minute. You are appearing for?
Respond number 2. In the meantime, process is on. Well, mine three meetings has already been conducted, my lord. And ultimately, we have to pay that particular amount, my lord. That process is still on. Ultimately, we have zoomed in that that amount, that goods have been taken. That goods which they have ordered, they have taken. But that price, that price is they will be in the higher side. That's the issue.
Everything has been admitted by the respondent. They have verified. They found the articles which have been supplied by the petitioner lordship. Only they are.
Where's the order?
Page number.
Order page number 36, lordship.
35.
35.
11 parties in 30. Page number
36, lordship. Page number, para number 4, lordship. 0.5.
Yes, what is your problem?
In the meantime, the committee was formed, they have examined it. There is no dispute that these materials have been supplied. Only thing is that in the meantime, they examine the price which was fixed in the earlier is in the higher side. That's the issue.
But that price was approved by you instead.
There is that particular document. Lordship will fix it after 10 days. In the meantime, I will get the entire instruction because they have not fixed the price also. They say only that the price is in the higher side.
But earlier when he supplied the goods, you fixed the price.
That is
Then how can you turn around now?
My lord, that's Lordship will fix it after 10 days. In the meantime, I will advise them.
Okay, heard Mr. J. U. Ahmed, then counsel for
Date,
the, on request made by S. Boral and the counsel appearing for the response number 2. How much time?
After 10 days, immediately after 10 days.
Observation may be given, lordship, because he is saying since last many years, lordship.
List the matter.
Process is going on, lordship.
2nd April.
57,
In here also, the respondent number 2 has been amended, my lord.
Amended?
Yes, my lord. Mr. Akasti is there. Respondent.
Who was appearing for Auguste in the earlier thing? Bora. Yes, Bora.
Lordship, here I am appearing for the earlier incumbent. Honorable Goel. He has now been transferred to the as a election commissioner.
You have any instructions to appear?
My lord, I will file my affidavit at the power meeting.
But a Bora. Learned counsel for the petition. Mr. S. Boral and its counsel appears for the response number 2 and praise for how much time?
2 weeks.
2 weeks time to enable him to file affidavit, to receive instructions and file affidavit. List after 2 weeks.
58,
My lord, in the office note dated 5/12/24, there is a wrong entry that the notice was issued to the respondent number 4.
1 minute.
But actually, it was respondent number 2, my lord. The newly
5.
Respondent 5/12/24, my lord. Office note, there is a wrong entry that the notice was issued to the respondent number 4, but actually it was respondent number 2, my lord. Accordingly, this honorable court in order dated 5/2
1 minute, 1 minute.
Yes.
Where's the order?
Official order 5/2/25 is reflected, my lord. 5/2/25 order is reflected, my lord.
In the office note?
No, my lord. Order dated 5/2/25, my lord. If your lordship.
This court's order?
Yes, my lord.
next page with us.
It is mentioned, my lord. 5/2/25.
5?
2. 5/2. 5th February, my lord.
Oh, 5/2/2025. Yes.
It was mentioned that, my lord, in the office note, it was wrongly mentioned that the notice was issued to respondent number 4, but actually it would be respondent number 2. Accordingly, it is corrected, my lord, in the office note dated 25/2.
25 to office note that it was wrongly mentioned as respondent number 4, but it will be respondent number 2. That neither ID card nor consignment is returned back, my lord. Respondent number 2, my lord. So may I pray for my lord taking a justice service, my lord, within 1 week, my lord, for 2, my lord.
Contempt.
Yes, my lord.
In contempt, can you take dusty service?
Otherwise, my lord.
Who's the respondent number 2?
The commissioner, my lord, the newly incumbent.
Just check up. Gogoi, just assist his court. What is this? The PNRT department. Maybe you'll know the name. What did this guy?
Earlier was transferred, my lord. Earlier incumbent already filed affidavit, my lord.
One guilty Jali. Oh, yeah. Just check up if this is the commissioner PNRT.
Lordship, as Doctor is pursuing this matter, but he is on leave.
Present Kirti Jolly.
K. Jalde.
Huh?
K.
K. Jali.
Jalde.
Okay, fine. So who's appearing for him? You have.
Lordship.
He will appear.
You will appear.
Lord.
Okay, heard Mr. M.G. Katil and the counsel for the petitioner. MS.
N. Bora.
N. Bora, then standing counsel.
PNRD.
PNRD, MS N. Bora, learned counsel, huh? Appears for the respond number 2 and prays for 2 weeks time to enable her to receive instructions and file up. List after 2 weeks.
My lord, may I pray for a date, my lord? Can it be a fixed date?
Okay. 9th April.
9, oblige.
59.
May I please the lordship, my lord, this contempt petition has been filed for violation of the judgment and order dated 7/3/2024, my lord. The operative portion of the order is at page 15.
Lordship, as Doctor is pursuing this matter, but he is on leave.
Your lordship may fix some other day.
Heard Mr. D.B. Boral and the counsel. On request made on behalf of Mr. S. Dr. Leonard Counsel for the respondent number
Respond number 125.
1 and 5.
125, my lord.
It's 1 and 5.
125.
1 and 5.
1 and
125 because.
It's 1 and 5.
Yes, my lord, yes.
When do you want?
Maybe a
Like logo, when do you want to be there?
this after 2 weeks.
Yeah. 7th April.
60.
Obligement.
Lordship, Lordship, judgment in order is at page 22, Lordship. Operative part is page 37. They have not complied, Lordship. Direction was to make payment within 15 days.
Where's Gogoi? B. Gogoi.
Next week,
First
week of April, Lordship. First week of April.
Learned counsel for the petition. On request made on behalf of B. Gogoi, learned counsel for the respondent. This is the matter on, this is the matter on, okay, 2nd April.
61.
He was issued, my lord, and returnable today. And steps taken, my lord, steps could not have been sent as per the office note. Because CIS system, my lord, doesn't permit. So I need, my lord, 2 weeks time. Well, to Steps was, my lord, taken perhaps.
How many respondents are here?
5 respondents.
6 respondents are here.
Respondent.
Then
Third. Including the state was on 6. A step was taken perhaps on Mr. M. Madhe, my lord. He is out of station. Now, my lord, I need 2 weeks time, my lord.
okay, on your request, I'll just say 2 weeks time. On request made by Mr. A.K. Purkayastal and the council. This up to 2 weeks.
2 weeks, my lord.
62.
Meantime, you do the correction, whatever.
My
you
lord, my lord.
For Planet Lodgema Court, order lordship, all the services upon all the respondents have been completed, lordship. Maybe we have to start for admission, lordship, by next month.
Okay. Heard, Mr.
D. Dole, lordship.
D. Dole, learned counsel for the petitioner. Peruse the proceedings of the Lawazima Court dated 12/3/2025. The notice on the respondents 6 to 10 shall be deemed to be complete, 6 to 15. List the matter after 3 weeks in the admission column.
63.
May I please, your lordship? In this case, my lord, we have taken steps upon the respondents, my lords, but no ID card, neither answer notice is returned. But matter may be listed after 2 weeks, my lord.
When did you take steps?
Lordship, as per notice to dated, my lord, it was
Okay, yeah.
taken on 5/3 of 2025.
Await service report on the respondents and list the matter after 2 weeks.
Obvious.
64.
As per office note dated 12/3/23, my lord, service is not complete upon the private respondent. Back.
Await service report on the respondent number 7 and list the matter after 2 weeks.
There is an interim order.
Interim is there?
Yes.
Interim order partial, you have to continue till the next interim date.
Much obliged.
66.
My lord, the I is for my lord, stack of the name of my lord, respondent number 1, my lord. Yes.
Respondent number 1.
Yes, my lord. Since my lord is not an necessary party, my lord.
The contempt matter?
My lord, contempt matter. I have filed an IA for stack of name of respondent number 1, my lord, Malansa Goswami, my lord.
Mona Lisa Goswami. Why is she not a party?
She's not a necessary party, my lord.
Yeah.
And my lord, next, it may be disposed of on the next, my lord, contempt petition, my lord, 651, my lord.
Lordship, regarding the
What do you want?
My lord, at page 25, my contempt petition, my lord,
Oh.
contempt number 651, my lord. Page 25.
Oh.
Kindly see, my lord. Last para, my lord. If it is found that the petitioner entitled to the amount of 1,43,61,600 or any part thereof, the same shall be paid within 4 months from the date of certified Cooperative instant order is served upon the superintendent GMCs, my lord. We have served, my lord. Despite that, my lord, we have a contract, my lord, regarding, my lord, disposal of, my lord, waste management.
that this my lord fracture materials and all this my lord. We have my lord doing this for last my lord 5-6 years my lord. They have not paid my lord. So my company is now suffering financial crisis my lord. Despite this order my lord, they have not my lord complied with my lord.
You happy?
That's the main counsel regarding this matter. But regarding the IO, we have no objection. It can be struck off. But regarding the content matter, the main counsel is arguing this matter. He's on legs in court number 4. If it is all right with the lordship, can this matter be taken out after some time? If it is convenient to the lord.
No, first thing is this, your IA will have to go.
My lord, yes.
After your IA, you'll have to file an amended cost title. Correct?
My lord.
Then only we can consider your contempt.
Yes,
It's not the issue. It's not the issue that the contempt will be taken up today.
My lord, I may be disposed of my lord because only it's online stock of the
That's
name.
fine. I'll dispose it
My
of.
lord.
But the contempt we can't dispose it of today.
My lord.
Heard Mr. Tribulus, we're going to counsel for the applicant. You're April? Also heard Mr.
M. Bhuya,
M. Bhuya, learned counsel, appearing for the
respondent number 2.
Respondent number 2. Stop. By this application, the applicant who is the petitioner in contempt case 3651 of 2024 is praying for deletion of the respondent number 1 in the said contempt case on the ground that the respondent number 1 is not the necessary party and has been wrongly implemented. Stop. But Mr. M. Bhuya, learned counsel for the respondent number 2 has no objections. This court has also perused the course shown in the present application and is satisfied. And accordingly, the prayer for deletion of the respondent number 1 in contempt case number 651 of 2024 is allowed. Para in the contempt case, in view of the order passed and so, let so and so be deleted as party respondent number 1 in the present contempt case. Petitioner is directed to file an amended cost list of within a period of 1 week from today. List after 2 weeks.
Maybe a date may be fixed, my lord.
Date will come up to. I'm fixing the all some fixed
On
matters only
my lord,
will
on
come
7th
up.
of April, my lord. On 7th of April.
Okay, 7th April.
Obliged.
67 of supplementary list ordered.
The proposal has been submitted for sanctioning the ceiling for the amount, and it was submitted on 21/1/25. So let it be, my lord, in the first week of April. If it is sanctioned, my lord, then they will get the amount.
What is this called?
Say a ceiling proposal, my lord, at a heading, my lord. Ceiling request of civil engineer so and so. And in fact, my lord, the contempt number has also been mentioned in the first line. In the right hand side, my lord. Contempt case 307 of 23, arising out of repetition number 4700 of 2022. Rajiv Sarkar versus Terwasa.
This ceiling request is made to the finance department.
Yes, from the PWD. I am appealing for the PWD department here. So let it be, my lord, in the first week of April.
Okay.
No, if it is sanctioned, they will get the money.
It's going to be 10 years. He has submitted his bill.
Something is happening at least.
Yes.
But
S.
Dev. Learned counsel for the petition. Mr. B. Gogoi. Learned counsel appearing for the respond number.
My lord, here 2 and 3. My lord.
2 and 3 submits that the proposal for ceiling requests for payment of the pending dues to the petitioner has been sent to the finance department on
my lord 21/1/25.
On 21/1/2025. Stop. He accordingly prays for some time to enable him to receive further updated instructions.
Date
Praise
will be
allowed.
fixed, lordship.
List on. When do you want Gogoi?
Let it be on first week of April, my lord. Any day.
Okay.
On 4th,
4th April.
Obliged.
68.
May please your lordship.
My lord, in this case, as per Lozima order dated 13th March, my lord. 13th March, 13/3. Lordship will see, service upon respondent number 8 is deemed served, my lord. So service is complete. Otherwise, my lord, here it is an admitted liability of 1,44,11,300 by the executing as well as the paying department at page number 30. That is the water resource, my lord. Lordship, I need some time, Lordship.
Okay.
My lord, may I pray, since the other two matters were fixed on 4th April, can this
First,
also be?
Mr. D. Chakravarti, and counsel for the petition. Peruse the proceedings of the Lavazima court dated 13/3/2025. The notice on respondent number 8 shall be deemed to be complete. This is a writ petition. Okay.
It is a writ.
Mr. C. Sharma, the Standing Council Water Resources, prays for 2 weeks' time to enable him to receive instructions. Stop. Prayers allowed. List on 4th April.
My lord,
The,
for-
admission call.
Yes, for example. Deeply applied.
Finish.